your cooperation, and it's my hope that we all do our very best today together.
Yeah, leave it right there.
Okay. Our ticker is better, Court TV.
Yeah.
All right. Well, hello, everybody. We are doing a stream on multiple channels today. We're going to cover the Tyler Robinson hearing. It started about 10 minutes ago, so we're backing it up. And we're going to watch from the beginning. So be sure to hit that like button. Hit the subscribe and unsubscribe button if you feel so inclined. I'm impatient. Fast forward. There we go. There we go.
Novak, Michael Burt, Stacey Visser, you're on behalf of Mr. Robinson.
Good afternoon. Good afternoon to you, counsel. Mr. Robinson, good afternoon as well.
Good afternoon, Your Honor.
All right. Before we turn to the defense's motion, the court would like to address 4 preliminary matters. First, in regards to the transcript from the December 11th hearing. Counsel, I would appreciate your input regarding the transcript from the December hearing. The transcript has been designated as private, and copies are available to the parties. Consistent with the court's prior handling of the October 24th transcript, the court intends to release a redacted version of that transcript, but I want to get your input before making a decision.
Judge, we intended to do that as well. We haven't stipulated, we haven't come together to stipulate on a version of that transcript that should be redacted. We certainly can do that, and we're happy to do that.
Thank you, Mr. McBride.
We will meet and confer with Mr. McBride and his colleagues on that.
All right. How much time is needed by the parties?
2 weeks.
That's fine. A couple weeks.
All right. A couple of weeks, and then we can address that. Next, I want to turn to address media coverage and place on the record the potential consequences of any willful violation of the
this started about
December
15 minutes ago, so we
2025
started from the beginning
decorum
so you can
order.
watch.
Under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. Any alleged violation will be carefully evaluated, and the court will impose only those sanctions which are appropriate and proportional under the circumstances. The court will make specific findings on the record before imposing any sanction. In addition, the court may impose the following remedial measures if warranted. First, immediate suspension of video transmission of the hearing, with proceedings continuing on audio-only basis for the proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter, where the court determines that such a measure is required to ensure compliance with a standing decorum order and to protect the rights of the parties. Counsel will be allowed to provide their input before the court makes any final determination regarding sanctions. I want to emphasize that these measures are not intended to have a chilling effect on open and transparent courts or on responsible news gathering, and the court remains fully committed to the presumption of open proceedings under applicable rules.
Have you seen anything like this at the drugstore? No.
I got it too.
Look,
What the
optic
fuck?
is me. Them
Wahaha!
Oh, what?
Ew.
What?
The Supreme Court
You yelled
decision,
at me.
which is called
What?
State
You
Jimenez,
yelled at
JIMENZ,
me.
The fuck?
which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the
Motherfucker.
type of a case.
I think
I'm
it
not saying that
jumped.
Oh
Jimenez
no, it was a court
compels
TV
that
ad.
action, but it seems to me to strongly suggest.
Look.
magnification in the bottom.
It's a fucking.
No.
It's not. Ha!
Put my
Ha!
Things are clear.
Ha! It
I
wasn't
simply
me.
want to
Ha!
ensure that the
It wasn't
guidelines for
me.
today's proceedings are clear. Mr.
We
Yulberg, during
both got
today's
fucking
hearing,
cocked
what is your
by court
primary
TV.
role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd,
Wait, can you rewind
2025
that? Because I
standing
didn't hear it
decorum
the
order
first time I
Yes.
watched it, and
To
now I
be
didn't
sure
hear it
my
You
again.
don't have to borrow optic.
Yeah.
intended to
Fuck
have a
you, Court
chilling
TV.
effect on open and transparent courts or on responsible news gathering. And the court remains fully committed to the presumption of open proceedings under applicable rules.
Have you seen anything like
Look at
this
that
at the
shit,
drugstore?
dude.
No, you
This
haven't.
isn't an ad, dude. It's from the court
Look,
TV.
optic is making the most beautiful readers. This is
Yo, we both, Secret and I both thought that our ad blocker and shit fucked up, dude. But this is from the court
floral
TV.
and champagne.
Look at
I'm
this
wearing
shit.
a progressive lens.
So
Like,
look,
like,
you can even see it behind their watermark. Court TV's got the skip ad button. So they're restreaming this from
Yeah.
someone else.
Means it's clear up top.
Super
I've
yelled
got
at me too.
magnification in the bottom.
I did. I admonished her.
Only where I need
Like,
it.
no,
So if I'm
watching
looking at my
mine.
cell phone or reading
Oh
a
my
book,
God, we
I'm gonna
both
be
got
looking
cut.
down. If I'm driving a car or watching TV,
All right, Chad.
I don't-
I apologize to my sandwich maker for yelling at her because I thought the ad block wasn't working. We did the.
I have to suddenly put my glasses on to read something because
And then look.
I don't have to suddenly put my glasses on to
You
read.
can see whoever's controlling the court TV stream. Watch, they pull the cursor over.
If I'm driving a
Here
car
it
or
comes,
watching
ready?
TV, I don't have to suddenly put my
From the
glasses on
left,
to
here
read
comes
something.
skip ad.
Because
It's not my intention to cause you any
The
embarrassment
court TV can't even
Yo,
pay
whoever's
for
court
premium.
TV, you just fucked up. Yo.
or discomfort. I simply want to ensure that the guidelines for today's proceedings are clear.
So we missed about 20
Mr.
seconds.
Yulberg, during today's hearing, what is your primary role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd, 2025 standing decorum order?
Yes, sir.
Do you understand the guidelines as they relate to your responsibilities today?
I do.
Do you need any additional time to review the December 23rd, 2025 standing decorum order, or any time to reposition the camera to ensure full compliance with those guidelines?
Do I need more time? I'm sorry, was that the question?
Do you need more time to review the decorum order? And I'll pause there because that was a compound
Okay.
question. Sorry about that.
No, I've read it. I fully understand it. I'm good to go.
All right. To the second part, do you need any additional time to reposition the camera to ensure full compliance with those guidelines?
No, I think we're in a good position now.
All right. Mr. Yulberg, do you anticipate any difficulties complying with the December 23rd, 2025 standing decorum order?
I do not anticipate any problems.
All right. And is there anything that the court can clarify to assist you?
No, I think we're good to go, sir.
All right. Thank you, Mr. Yulberg.
Thank you.
Before I let you go, I'll turn to counsel based off the questions asked. Turn to you if you have any input or questions.
Nothing from the state.
Thank you.
No, Your Honor.
All right. All right. And the court, I appreciate your cooperation, and it's my hope that we all do our very best today together.
Absolutely. Thank you.
And finally, before we turn to the issue, the motion before the court, to the state, could you please provide a brief update on the status of discovery disclosure?
Yes, Your Honor, I don't have the percentage of materials that we have that have been disclosed, but I think we're above 90% at this point. There still is discovery coming in, there are reports and so forth coming in from various entities. So I think we're moving expeditiously towards completing at least this initial batch of discovery. Of course, discovery will be ongoing probably for the duration of the proceeding, but we have provided nearly all of what we have to date.
All right. And to defense, any input?
None at this time, Your Honor.
Thank you, Ms. Nestor. All right. Thank you, counsel, for your patience as the court covered those preliminary issues. Let's turn to the defense's motion to disqualify the Utah County Attorney's Office. Ms. Nestor, or sorry, Mr. Novak.
That's fine, Your Honor. That's okay. We actually have some preliminary things we want to discuss with respect to the posture of this motion. And I also think at some point the court needs to decide what stage the hearing on this motion.
All right, everybody, just a reminder that this started about 20 minutes ago and we're backing it up so you guys can basically catch it all. We're just going through the initial proceedings and all that good stuff. I think Secret is having technical difficulties with her mic. I believe she is.
How about now?
Oh, there you go.
Okay. Sorry, guys.
Can I press play?
Please think. Hello,
It
everybody.
remains open and becomes
This is
closed.
court. Court's live. We can't pause
Keep
the
bear
show
that in
for this
mind
shit.
in preliminary statements, if I may.
But remember, everybody, this is day one, so we're showing this sham here.
When we filed this motion to disqualify, and when I say we, I mean Mr. Robinson's counsel, we fully expected that what the Utah County attorneys would do is refer the motion to the Attorney General's office so that the Utah County attorneys are not in the position of representing their own interests as potentially conflicted attorneys and a potentially conflicted office, and representing the state's interest in the prosecution. We heard informally from the state's attorneys that they were preparing a response and when it would be provided. And then what we received, and again, I'm bearing in mind that we're in an open hearing at the moment, was a brief where I'm going to say the unsworn representations of two attorneys from that office are basically integrated into points and authorities. We don't have affidavits from Mr. Gray.
And we will be answering your
We
questions
have
at
our-
different pause breaks.
We noted in our reply
So we're not ignoring you.
that we were
But we are.
surprised, that's in footnote 2 at page 4, that the Utah County attorneys were representing themselves in connection with a motion alleging that they have a conflict of interest and that the state was not being represented through the Attorney General's office. We did some further research on this and we have some case law that we can provide the court. I suspect that the court is very familiar with the fact, just from its own experience, that in appropriate circumstances, the Attorney General's office can either, one, represent the state in what was a county prosecution with respect to a disqualification motion so that the boundaries are clear, or if there's an ultimate finding or conclusion that there's a conflict of interest, take over the prosecution or assign it to another county. So we're very concerned that we're getting off on the wrong foot, if I can use that metaphor, because we have officers of the court who are both representing their own interests in continuing to be the prosecutors in this case, and representing the state in a situation where there should be what I would call, at least temporarily, conflict counsel. I'm not sure that's the term the Attorney General uses, representing the state's interests. There's a Supreme Court decision which is called State v. Jimenez, Jimenez, which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the type of a case. I'm not saying that Jimenez compels that action, but it seems to me to strongly suggest that where there is a showing, I'm not sure what the threshold showing is. I don't want to say it's a prima facie showing or a reasonable concern, but where there's a showing that there very well may be a conflict of interest that hasn't been handled by a particular state attorney's or county attorney's office, that what's in the interest of the litigation, of the public, of the parties, is for the Attorney General to step in. And the citation for State v. Jimenez, if I may, is 588 P. 2nd 707. Of course, I can provide the court with the Utah citation as well. This court actually has the authority under that case, State v. Jimenez, to direct the Attorney General to step in, not for the entire case at this stage. That's not what we're saying is necessary, because that requires a finding of a conflict of interest, but to step in or to designate somebody to step in for the purposes of litigating that motion.
Okay.
And so we're very concerned that even going forward with an evidentiary hearing where members of the Utah County Attorney's Office are both litigating as representatives of the state in a prosecution and essentially defending their own propriety of proceeding in this prosecution is problematic. As far as being prepared, we're of course prepared to go forward with an evidentiary hearing, but we think that it's improvident. And we think that what the court should do, if the Utah County attorneys have not or don't, if given the opportunity, do this on their own, is that the court should designate the Attorney General's office for the purpose of litigating this motion. The court might ask, hypothetically, the question, has the Utah County Attorney's Office conferred with the Attorney General about this particular question? And we are not in the dark, because as Ms. Nestor will tell the court, as an officer of the court, she's spoken with the Attorney General's office and they have not been consulted about this. Okay, so this is a motion to disqualify a county attorney's office based on what we believe is a material, significant conflict of interest that it's clear they haven't even tried to address by way of a screening, which of course is a term of art, because their position is no screening was necessary. We're not even here to discuss whether the way in which a particular attorney was screened off was adequate. Their position as their own advocates is, we've already decided no screening is necessary. So we've been told by the Attorney General's office, Ms. Nestor can represent to the court exactly what she was told, but basically that there has not been consultation. And while that is Mr. Gray's prerogative, we think it's wrong. And we think that this court needs to exercise its authority to intervene and say, in this case, for this kind of a motion, the court needs to hear from a representative of the state who does not even appear to have a conflict of interest. So that's our preliminary statement about these issues. And again, I hope I've avoided saying anything that should have been said in a closed hearing. I think I was pretty good about that. So that's where we are.
That's basically
before
how
we
I'm
even
feeling
get
about
into
this
the
whole guy.
litigation. And
Like,
I don't
all
want to
right,
be
Mal.
formalistic, and I'm certainly not
All
trying
right.
to be confrontational, but I think actually what we think the court should do is the court should strike the Utah County Attorney's response to our motion and direct the Attorney General to take up the responsibility for responding to our motion in whichever way clearly non-conflicted attorneys representing the state think they should, how it should be responded to. And if I've muddled, I always say this, Your Honor, if I've muddled anything or confused anything, please say so and I'll try to clarify.
Thank you. I do have some questions for you as it relates to this. I wish to consider all the authority that you wish to cite to. I mean, obviously you came into this hearing knowing that this is something you're going to present. And this court wants to be efficient with time, but thorough.
Yes.
And not jumping to conclusions. Can you give me all the authority that you wish for me to consider in considering your request today?
Yes, and I think what we could also do, which maybe would be more helpful to the court, is that we could file a short brief on this particular issue, because I will acknowledge that while we were surprised that the brief was filed by the same lawyers who are alleged to have this conflict of interest, it took us a little bit of time and we wanted to get that filed in time for today's hearing because the court had set the hearing. It took us a little bit of time to think through these issues. So there are Utah authorities, there are authorities from other jurisdictions. There are also ABA guidelines on the prosecutorial function, which we think strongly suggest that there should have been what I'll just call a referral to the Attorney General's office for this particular motion. I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot and require the court to, like, go back into chambers, think about it for, some pressured period of time and come back out and make a decision. So if it would benefit the court for us to file something, and I don't mean in a month, I mean very soon, so that the court has thoughtfully presented points and authorities.
Yeah, this is going to be a
how
big
we
nothing
draft.
burger of just procedural crap today, guys.
As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself. So I'm thinking about the convenience of witnesses and the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court is open to receiving authorities, that we recess this hearing for, whatever meets the court's schedule, whether it's a week or 2 weeks or a few days, and we can provide the court with something, and we'll come back. But we do think this is a serious issue, because I think the question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right.
Thank you.
Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that this would be in this position based off your request?
Yeah.
Prepare the court, prepare opposing parties, and to be efficient. in our
Why are you
use
doing
of
it now,
time.
Chris Ryder?
I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what
Exactly,
the court does.
Linda. This guy is very, very.
I hear what the court's saying, and I think we can take responsibility for not sufficiently.
I gotta pause him for a second. Yeah, the judge is really like, okay, why didn't you fucking submit this shit beforehand? If you're wanting a motion to extend or a stay here, Why did you not submit this shit? Furthermore, why are you like, well, it's up to the court's discretion. 2 days, 4 days, 2 weeks, 2 months, 2 years, whatever the court decides, Your Honor. I'm not putting forward any time frames here, but whatever what's most
Is this the
convenient for you?
defense attorney?
Yeah, Tyler's fucked.
This guy's yeah, you're a moron. Get
He's
him
so
out.
fucked.
The
Presenting
girl is like
the authorities
girl's
that we
way
think
aggressive.
compel what I've just suggested
Like,
should happen.
get to the point. You're
We noted in our
Yeah.
reply brief
defense
that the
attorney. You're supposed to
county
be
attorney
like
should not be representing themselves. And that's
balls to the
probably
wall.
an inadequate message to the court, but we did file a motion to disqualify. And inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflict.
So do you remember? I don't know if any of you guys saw it, but do you remember when they did the other one back when, like, they were talking when they first started talking about the the media showing the computers and stuff? That the lady, they wanted to like move forward with something, and the lady stood up and was like, whoa, no, because we have over like 4,000 pieces of discovery that hasn't been sent to us. And she's like, no, I'm not doing shit until I get this discovery. And the judge was like, that's fair. I mean, she's like, she was polite and nice, but she was like super assertive and was like, they told us they have this many pieces of evidence. We haven't received it, so no.
Right.
Yeah, he needs better
appropriate
attorneys.
prosecutorial
At least this
authority,
guy.
which, as I've done further research, and Mr. Bird and Ms. Visser and Ms. Nestor and I have all done further research, literally up until earlier this morning, we think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue. So I'll fall on my sword. If the court thinks I should be sanctioned for not bringing this up sooner, I hear the court, but we are
Good Lord.
We're juggling many aspects of this case all at the same time, some of which the court is aware of, some of which the court probably is not.
If you're not equipped to
the
handle it,
court can
hire more
imagine.
people or get
No,
out.
and I appreciate that. It's not the intent to sanction you. I understand that issues come up and there's a lot going on. And so the court appreciates your candor and representation today. So these items can evolve. And so the court is not finding fault with you. It's just hoping that as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party.
Glad we
and
caught this from
for
day
other
one.
parties. We just might want to make sure we make the best use of our time when we're together.
I hear everything the court is saying. I take it to heart. I understand what the court's saying, and we are cognizant of the time that the court devotes to preparation for these hearings. So that's all I can really say.
That's right. And also for Mr. Robinson himself and the victim representative.
I'm
in his court as
surprised
well.
the judge
We
let him
just want
cut
to,
him off like that.
do our best, and I understand. And I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happens, so I understand. I'll turn to the state. Oh, and I'm sorry. Is there anything further that you wish to represent?
No, like I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court a list of verbal citations. I think
Hold on.
with all consideration for, and we probably have, with all consideration for the fact that the court wants to be thorough and careful, and we do as well. We don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way Once,
I wanted him to finish that train of thought, but he sucks.
We'll be here
Trying
forever.
not to cut them off while they're like speaking, so we'll do like when they're like taking breaths or something.
Okay. So he is talking about how much that they're doing and how much they have. Do you know how many law students would love to help on this case for free?
Oh, well, he's not saying that they don't have those resources as well.
Wait,
Yeah.
what?
He's going to say that we're doing all the work, but even though we have a whole conference room of law students doing it for us, I'm doing all the work, Your Honor.
Oh,
This is
yeah.
me. I'm doing all the
He's-
works here.
Yeah.
He's not
It's
going to
like-
tell the judge, yeah, I got a whole fucking conference room full of fucking, 21-year-olds doing this for me.
Yeah. He's being a little bitch.
Yeah. Damn well when he was like, oh, even up to this morning, yeah, you had your fucking all these people doing it for you, bro, as you were driving to court.
All he's doing
We
is
understand.
presenting it. Like,
Yep.
you're a moron.
not only the way this was developing, but, frankly, the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and, the information that we received today from the Attorney General's office, which isn't a secret. It's just, we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll
And
go ahead
I'm
take
pretty
those
sure they
authorities.
already have their mind made up. This is just the theatrics of it for the public.
Right now, if you'd like to list them, court is ready.
So the second one would be State v. Robertson, and that is also a Utah case 886 P. 2nd 85. There's the ABA prosecution standards. I would refer the court to section 3.1.7 and 3.2.5. And those are, I think, the places to start.
Is there any
So
Utah rule on
unprepared for this.
point
I
that
don't have my
addresses
notebook
this
to write
issue?
those down so we can look them up.
So the case of State v. Jimenez, which I referred to, which is the Supreme Court, does actually cite a statute.
Anything further that you wish for this court to consider at this point in the proceeding as it relates to this issue?
State.
No, and depending upon the statements of counsel, we may have some response if the court permits it.
Of course. Thank you.
I think I
Turning
got
to
him.
the state. Mr. Gray.
Your Honor, I'm not sure why this is coming before us today. If it was such a surprise to them more than a week ago, I don't know why they wouldn't at least notify the court.
Right?
I too represent the state. I'm an elected official, constitutionally elected to represent the state. Where does this end? I don't know these cases. I'm very interested to see whether or not they refer to trials. I know that the Utah Attorney General's office, they've done the same thing that we have in Rule 11 motions, where one counsel on the team examines their boss, in fact, on the matter. So I just think this is ambush and another stalling tactic to delay these proceedings. There's no reason that they could not have at least filed the motion and asked for time to brief it. And where does it end? Do we get to respond to their motion to have the Attorney General's office respond, or does the Attorney General's office have to respond to that one too? I'm not, well, anyway, I've stated my, it should have been done far earlier if that was their case, if that was their claim. And if I could just turn the time over to Ryan in case he has something else.
Thank you, Mr. Gray.
Yeah,
Mr. McBride.
And excuse me, this is, we're tag teaming this somewhat because it's a surprise to us as it is to the court. But in the 5 minutes I've had to read Robertson and Jimenez, which could have been provided to me before this hearing, it looks like those cases don't stand for conflict of interest cases. They're actually, does the Attorney General's office have authority to prosecute cases that occur within a prosecution district or county attorney's jurisdiction? And the answer is yes. It's not about taking conflicts. From the few minutes I've had to read those cases, I do want to state this is, of course, the first time this has been raised to us. The defense has known that we were going to respond to this motion for some time. We requested an extension for our filing deadline back in December. The defense agreed to that extension. Our reply was filed January 5th. The defendant's reply was filed thereafter. And in that reply, the tone of that reply is mentions that they thought that perhaps a special prosecutor would be appointed to handle the conflict case. But in the alternative says, we'll be able to, we want to subpoena witnesses to establish the facts that are laid out in the state's opposition motion, a memorandum. And that was what we understood was going to happen today. You have a family member of a prosecutor who has been subpoenaed. An affidavit has been supplied to the court. We believe that affidavit is adequate, but it wasn't adequate from the defense perspective, so they subpoenaed that person. Prosecutors have been subpoenaed for today's hearing. We have 2 investigators that have been subpoenaed for today's hearing. And we are ready to go, Your Honor. I think that the motion,
Oh,
the
yeah,
request
they're
the defense
fucking
has made
ready.
assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true. If there is a conflict, which is the question that this court is to decide, the case will be referred. Until that conflict has been established, the case is properly in the jurisdiction that has statutory authority over that offense. And until that conflict has been established, the Utah County Attorney's Office has this case and can defend its involvement in this case. I got just a moment to review my notes and see if there's other points we want to make on this.
Of course.
All right, we got a moment of review here. Let's talk, everybody, while they're reviewing. Everybody talk before the judge admonishes us.
There is one other point I wanted to make, which is
Never mind.
the idea that the case would be referred, that alleging a conflict would cause a special prosecutor to be appointed. That really assumes that there is a conflict, and until that conflict has been established, there is no duty for the case to be referred to another jurisdiction or another special prosecutor to handle. And it raises some of the issues that have been brought up in some of the case law regarding creating or
Exactly.
alleging conflicts. There's a lot of case law that talks about how it can be a tactic to
And we're watching it unfold live.
One prosecutor's authority to find a more lenient prosecutor, find a more favorable prosecuting authority that's not going to.
Did you just see him yawn?
And there's a lot
No,
of case law
thankfully,
that
I
talks
looked
about
away.
you can't call opposing counsel as a witness in a case.
At this point, I'm going to talk
over.
over these
The
motherfuckers
reason is because
for when we got to
it can
opine.
be a forum shopping effort. And we're concerned with that same kind of motivation or tactic that could be used in this case or other cases like it. Anytime you, as opposing counsel, you don't like the offer you're getting, the way the prosecution is being handled, you allege a conflict of interest, and all of a sudden the county attorney's office has to spend $10,000 to hire a special prosecutor just to handle that one issue, regardless of whether or not it's supported or whether or not a conflict exists. That's a concern we have. Now, we're ready to go forward today. We think the evidence that will be presented today.
I hope the judge does not rule in the defenses.
eliminate
I want this to
the
go
issues
forward.
Adequate that Your Honor can make a decision about whether or not a conflict exists, and we don't need to delay this proceeding any further. We're confident the court will see the facts as they are and be able to make that determination.
Mr. McBride, so the motion has been made by defense to continue this hearing to allow the
think-
filing of a motion addressing more fully this issue. to that request, what is the state's reply?
We object to that motion to continue or to strike. We asked the court to go forward today. We think the motion is untimely. The court has, or the prosecution has subpoenaed witnesses, and every delay that happens, the witnesses that we have now family members of the prosecution being subpoenaed.
Yep.
These people are ready to move forward and get this out of the way. The longer we
Agreed.
delay this, the more
100% agreed to
anxiety,
both of your statements.
that this procedure has.
I hope they, I mean,
All right, thank you,
I don't
Mr.
want to see anyone thrown in
two
prison, and
defense,
obviously
any
this is a
response?
sham.
Yes, John, thank you.
I hope they fucking deny this objection.
First, I want to say this is not about seeking a lenient
Yep.
prosecutor.
Yo, you're Thomas
Not
Clay in
about
this shit, bro. You had a
this at
week
all.
notice.
And it was actually the county attorney's office who informed us back in October that there was a family member of a prosecutor who was present.
At this point, you're probably not avoiding therapy because of stigma. You're probably avoiding therapy because you've become very
This is a
good at
court
coping.
TV ad.
So good that you stop
Like it's
noticing
behind the
how
watermark.
heavy everything feels. As a therapist who goes
So you
to
can-
therapy
if you
herself,
guys look in
it's
the bottom
important
right
to
corner
remember
behind
that
the
your
court
mind and
TV,
body hold on to every stressor you
there
don't
is
have time
the
to
little
protect.
skip ad thing. So look, you can see their black cursor. So watch if
The
that
Utah County
if that was a
Attorney's
legit
Office-
ad, then I
Every
should be
stressor
able
you
to
don't
do
have
that.
time to
Back up.
protect.
Oh my god.
The Utah County Attorney's Office informed us in late October that we needed to know about this, and we informed them, fine, that's your position, it's not a conflict of interest. We think it is, and we intend to litigate it. So it's not a tactic, it's not something that we've made up out
So
of
while
whole
we're
cloth
listening to
because,
these
like I said,
guys-
we found a needle in a haystack. It's something that they properly brought to our
Oh yeah.
attention, but we firmly
Skirt, skirt.
believe that the law supports the
skirt.
conclusion that
So this is, because I was just browsing the tube streets when this came across and threw it up in the Speakeasy and was like, "Ooh, let's go live on this." So we haven't had a whole lot of time to talk about it, but where do you stand, Rabbit, on Tyler Robinson?
I don't think he did it.
Okay.
I
Do
mean,
you think he's involved at all?
as a patsy, maybe
I don't know what a patsy is.
a fall guy. I don't think he. I mean, the alleged security footage of him jumping off the roof with the rifle, like it's all bullshit. It's all bullshit. There's anyone who has handled firearms knows that the rifle that they fucking showed, you can't break that shit. There's just all the fucking rhetoric they put out there. Anyone who has any sort of knowledge whatsoever about firearms can tell that's fucking bullshit. They're lying, that we're being played. That's all I can say. Like, I can't speak on anything other than that. Just my observations on the shit they put out there. I'm like, yep, that's fucking bullshit.
And I am someone who knows zero about firearms. I am not an amendment person. I'm not a cop watcher. I'm really not into politics or any of that. I 100% do not believe he had anything to do with it. I think the text messages were fabricated. I think that
Oh, I completely forgot about the text messages.
yeah. I don't know how they picked this guy. I'm not sure because, I've seen, like, they showed the pictures of him in the stairwell. There's no way he's carrying a gun, anything like that. I don't know, like, what a patsy is or why he is targeted, but I believe that he has zero to do with it. But I'm not sure why they picked him. So
Guess we'll fucking
too bad we
never
didn't have
find out.
Too bad we didn't have opposing views, because then it would have been way more fun.
I know, right? Anybody have opposing views in the
Anybody
chat?
have
Want to come
opposing
up?
views?
That
Because I thought for
that
sure, I
particular
wasn't sure.
prosecutor should have been screened off. There's good case law on screening, which we did fully cite in our briefs in a timely way. And there was no effort to screen off that prosecutor. And that has now created a problem for the whole office. That is not made up out of whole cloth. And like I said, it's not about tactics or lenience or delay. This isn't delaying anything, at least on our part. The other thing that I want to point out is to say that.
So why do you want it to go forward?
Right. What's the point for the? Yeah.
Like why? No, I'm asking you.
Oh.
So why do you want it to go forward if the defense isn't ready?
I don't think that they're not ready. I think that they're just trying to delay it to get a better prosecutor in their favor.
What would you think a special prosecutor would?
Yeah, they're trying to get it moved out of, and they're trying to get someone from a different jurisdiction to run the case.
The prosecution.
Yeah.
Okay.
I mean, it's a common tactic.
Okay.
I tried to get it for mine, and obviously it didn't work. If I probably would have, I probably wouldn't have had a court of appeals hearing, but
Okay.
fucking go through with it, man. Because in my eyes, if the defense is not ready, they could probably claim mistrial down the line for some shit.
Oh.
I mean, fucking go, let them fucking go. Let the state berate and push you through on a faster time scale to where you can claim mistrial. Fuck it.
Okay.
That's what I'm thinking.
There you go. See, didn't know that.
Until this court decides there's a conflict of interest, somebody else shouldn't be handling this issue is circular. Because by that point in time, the court would have already allowed the conflicted attorneys to represent the state in a hearing on their potential conflict. So I actually think the way you avoid that circular argument and the sort of harm that arises if the court were to find that there is a conflict is to at least temporarily have the Attorney General's office handle this. Yes, Mr. Gray is an elected official, but that doesn't mean that his office doesn't have a conflict of interest. Conflict of interests arise. A judicial officer decides to
So if there were an actual conflict of interest and you get this shit on the record, right, as your for your reasons to for a continuance, then go through, if they deny it, go through with it and notate the fucking as the conflict of interest arises in the court case. And then when it does, file for a motion for mistrial. Like, Your Honor, we've stated that this conflict of interest, at the beginning, the court denied our objections or denied our motion for a continuance. Look, and this conflict has now arisen. I am proposing a motion for mistrial or something like that. I'm not an attorney. I don't know the legal speak, but fuck it. If they're going to deny your ass, play it.
Decides to become a judicial officer. That's actually where most of the cases.
Yeah, giggles. Yeah. You should have seen it fucking 20 minutes ago.
Oh my gosh.
There has to be a screening. The case law is very clear that the screening has to be adequate. There's been no screening here because Mr. Gray decided we don't think there's a conflict of interest. And what we're saying is it's not a needle in a haystack. It's not a tactic. It's not a fiction. It's not a thin reed. The evidence that the court has suggests, number one, that there's a very good possibility that as a legal matter, there's a conflict of interest. That's why we need to have an evidentiary hearing, because the court doesn't have all the facts. And number two, that the Utah County Attorney's Office, because they decided early on without consulting with anybody that they didn't have a conflict of interest, didn't put any screening mechanisms in place. And so I understand that they want to defend
this guy definitely worked with Thomas
the
Clay at one
decisions
point.
that they've made. But the question is, shouldn't the state be represented by somebody else in the course of this court resolving whether those decisions were right? Because to quote the law and to quote the ethics, the Utah County Attorney's Office is now serving two masters. I don't like that word, but that's the word in the doctrine. They're representing themselves and they're representing the state of Utah. And that's why
It looks like he's gonna puke.
the Attorney General or somebody else designated by the
Shit, I
Attorney
would.
General should be representing them in this matter. And I do want to say one more thing, if I may, Your Honor, and I appreciate the court's patience. I think that the way we raise this issue in our reply brief is not
Kelly.
as
Hey, Kelly.
accommodating to just letting it go as counsel suggests. What we said is we asked the question is whether it is even appropriate for the UCAO to litigate this issue on its own behalf. While the UCAO may have provided this court with the information that it has deemed relevant to this issue, the scope of the disclosures and litigation of this motion should have been assigned to another state agency, such as the Attorney General. We didn't suggest that this court should appoint a special prosecutor for all purposes, or that the filing of this motion means that the Utah County Attorney's Office is automatically disqualified from the litigation. That's the point of the motion, is whether they had a conflict of interest or whether they handled it. And it's our position correctly. And it's our position that the answer is yes and no. So
Secrets hiding in
I
plain
understand
sight.
there are witnesses here. People are ready to go. We think that
The world is
the court
ready to
should
go,
either
bro. We wanna
accept
see it.
briefing or agree with us that the referral is appropriate. And I want to cite, if I may, the citation by the Supreme Court in Jimenez.
Oh my God, this guy.
So this is 588 P7.
Ugh.
It's 707.
This probably might
but
be
this
one
is
of the most
at
boring
This is fucking brutal.
708.
cases.
This is the statute
follow.
quoted by the Supreme Court. If at any time after investigation by and a finding and a recommendation from the district
Wake
judge
me
involved
up
that the county
when
attorney
the
in any
defense
county is
attorney
unable
ends.
to satisfactorily and adequately perform his duties
Fuck,
in
dude.
prosecuting a criminal case without additional legal assistance, the Attorney General shall provide such assistance. That's very what that means in this case is it's inappropriate for the Utah County Attorney's
All right,
Office to
this is gonna
represent
be-
itself
All right, where's
when
the
a
sledgehammer?
well-represented
Fucking
state.
pin this shit to the brick
And
wall
then for
so it
this
does not come
motion,
down.
this court has the discretion, we would say,
Remember, everybody, we're
Respectfully,
streaming on like 6
obligation
different places right now.
designate the
So if you
Attorney
don't see
General
someone in the
to
chat, just-
represent
you know what? Let's do
the
this.
state,
We put all your guys'
the people of the
There
state
you
of
go. You
Utah
guys can see each other now.
in this motion. And depending upon
There.
how the court rules
There
on the
you go.
My
motion,
bad.
Now you guys can see each other.
Then
So
we
if
have
you're
to see what
oh,
happens.
there we go. Now if you're in
Your
different
position,
chats,
the
you
court
can
has
all
to
say
still
hello
make
and you'll be
that
on the
decision.
screen. There.
I think that the court has the discretion to say to the Utah County attorneys.
Oh yeah,
"You should be
we're
representing
killing
yourself
off
in
the
this
Benghazi
case
rabbit,
at
guys.
this stage as to this motion only.
So just
Continue to do what
be
you do
aware.
while this motion is pending. And we will resolve this
All of
matter.
everything is probably
I am
going to go
not suggesting
to
that they should
which
stop
one? Just
who
the-
knows?
the work that
The
We haven't
Savage
figured it out
Carrots.
yet.
about preparing
Yeah.
discovery,
Probably Savage
having their
Carrot.
agents interview witnesses.
Probably Savage Carrot.
Because that one's funny.
We
That
wanna
one's
get
got a
this
bunch of
motion
Chris
resolved
Ryder
in a timely
subscribers
way.
on
It
there.
is not a
Right.
But
The Savage Rabbit.
I'm not
Yep.
saying, let me be very careful because I don't want to misinterpret the court's question. I'm not saying that whatever this court decides is the right decision because the court has discretion. We believe that the law requires that the county attorney's office be represented by
You know,
somebody
we're
else
having the
in
drama-free
this motion.
stream
What I'm
over here,
saying is
guys.
The legislature.
Until
Give it time,
MBK
though.
fucking breaks into
the
the
authority
speakeasy. We chained the
Yep.
door shut, so who knows? He might
to
come in and
compel
like,
that
"Gaga!"
when the state attorney and the attorney
I
general
gave
haven't
him a
done anything
key.
about that yet.
Oh, you gave him a key.
I'm not
Fuck.
saying that the court
Yep.
I mean, I don't know what
Sorry.
what the standard of review on appeal would be. So
I
I'm not just
also
saying it's
gave a
it's an
key to
abuse of
Sorry,
discretion standard.
I'm just
What I'm saying is
talking over
the
this guy
legislature
because he's
gave
still
the
fucking talking about his motion,
authority
guys.
to
Ugh.
direct
Blah blah
for-
fuckity
to
blah.
the Attorney General
The judge already
representation
said
in
you
criminal
should have
case
filed this
where
last week,
there's
dumbass.
a showing of a potential conflict.
No, Linda, we did not get
And
strikes.
I've been a
It
criminal
is
litigator
something
on the
that
side for a long time. So I
Rabbit
understand what
has been
counsel's
talking about for
is sometimes
many, many,
defenders come
many,
up
many,
with,
many years, is that he
questionable
is very
grounds
much
and move to disqualify.
scrutinized on
And
his
I don't
videos and
think
his
that that's
lives
a
and
finding that
everything
the
that
court
is
can make
talked
in this
about.
case. It was actually, as I said
And
before, the Utah
because
County
of
attorneys who were concerned about this enough
things
that they
that
brought it to our attention.
he has
We
put
have
out
profound
and that he has
disagreements
done. And
Actual
so,
journalism, unlike Chris Ryder jumping on
hey,
bandwagon.
And otherwise, I think
yeah,
I would be repeating
so,
myself if I
and
said
they,
anything more
and
without answering
YouTube
it
doesn't like it.
All right.
So,
I just have a brief question. Do you have your witnesses here today?
yeah.
All the witnesses are here. We
And
have
I
no
can't
Oh!
post.
problem
Oh,
as
listen.
a
Oh,
pragmatic
sorry.
issue
Go back because I
going
missed it.
forward. Our witnesses are
Here.
the
You said
subpoenas that we served, which were filed with the court. So, but
He said all of
so
his
to
witnesses
be
are
clear, I
here.
don't think the court is inferring this. We're not unable to proceed if that was the court's
Oh,
conclusion.
deny
We
that
are
shit.
prepared, and the witnesses are here. I'm just saying, we think that it would be improvident and it could result in errors of law, and it could
Mistrial.
result in problems down the road.
Okay. Noted.
Thank you.
Denied.
Do you need
Move
any
on.
additional time in regards to your argument to continue this hearing based off the citations you've provided, the authorities you've provided the court?
1 second.
But as they're debating, yes.
What
So
the
that
fuck?
is what happened, is that YouTube is not being very
No, thank you.
nice.
All right, thank you. What this court intends to do is, this is an important issue, and I realize the totality of what's been presented. And my question in regards to your witnesses is, it was informatory. I just wanted to see if
They were here.
depending on what the court rules, if the parties, I don't want to disadvantage either party in that. So this is an important issue, and this court wishes to take a brief recess. I want to look at what's been provided and make see where the court needs to go. I want to inform myself, take a moment to look at it, and as opposed to just making a snap decision and taking into consideration all parties and the constitutional rights of all parties as well. With that, we will be in a brief recess. I always hesitate to give a time because
We'll be
sometimes I appreciate you being here. Court is in a brief recess. Thank you.
All right.
Okay.
So what happened?
They had a recess.
Oh,
So
so he's
thank-
gonna.
Thankfully,
Think
we
about
were
it.
talking, so let's see if we can.
Oh, they're still in recess?
Motherfuckers.
Were filed there. I will result.
Your argument. Take a moment to look at court informatory. I
So
just
he's
wanted
gonna
to see
recess
if-
and come back?
Depending on what the court rules, if the parties, I don't want to disadvantage either party in that. So this is an important issue, and this court wishes to take a brief recess. I want to look at what's been provided and make see where the court needs to go. I want to inform myself, take a moment to look at it, and as opposed to just making a snap decision and taking into consideration all parties and the constitutional rights of all parties as well. With that, we will be in a brief recess. I always hesitate to give a time because
We'll be
sometimes I appreciate you being here. Court is in a brief recess. Thank you.
Wow. Okay. Okay.
Hmm.
So let's put on some background music while we wait.
Basically,
All right. Let's go ahead and say hello to the chat now.
We'll go on and see if they're going to proceed with trial today or if he's going to issue a continuance.
Yep.
So, what do you guys think he's going to do? I think he's going to do a continuance.
I don't know. I don't think he. Well, the defense attorney just fucked themselves, and he's like, "My witnesses are here. We're ready to go. We're just, mistrial type of thing." Why are they restream? I don't know who's.
I don't know.
Stream they're streaming
It's
it
Core
from.
TV. It's Core TV.
Yeah, but they're definitely watching somebody else's. It might be like a local affiliate or something.
It could be like, from Pluto TV because Core TV is on Pluto TV 24/7.
Something, but they're definitely streaming something to where they have an ad and we don't.
Yeah. So Boot says, what do y'all think the over or under is that he issues a continuance? I'm just going to stop right there for a minute because what the hell is an over or under?
This is a betting terminology, folks. You're giving fucking terms that the blonde sandwich maker don't understand. Okay.
I've moved on from sandwiches because I'm tired of them. I'm now making cupcakes. So please explain to me what an over or under is.
Ooh, while there's a continuance, let's check on what's going on in Minnesota, shall we? It's snowing, guys. This is outside the ice facility out there in Minneapolis. All right, let's go ahead and catch back up on the chat. Oh, God. Sandwich maker, guys. All right, it's Giggles. Got the whooping crane. Got Linda, Boot. Kelly. MC did a gaff. Karma was in here. Karma, where'd you run off to? Uh-oh. Did y'all piss Karma off? Who pissed Karma off? Yeah. Hey, get y'all damn cupcakes off the screen. Uh-oh. Oh, no, guys. Oh, no.
I'm taking over today.
Oh, God.
Actually, we'll probably end this stream and restart one where I've taken over. Just let you guys all know.
Oh, God. They jammed the feed, everybody. They jammed the feed.
Thank you, Linda. Stuck that rabbit. I have also been in the garden. Picking some sweet peas.
Let's see here. Checking up on today's news, everybody.
Boot. Those are not, that is not lettuce. Okay? Okay? Those are sweet peas. I'm picking sweet peas.
Oh, wait, you know what?
Out of the
Actually,
garden.
you know what we could talk about? Hold on. That fucking press conference yesterday.
Carrot cupcakes.
Guys, I got triggered so fucking bad yesterday by watching the damn press conference.
What press conference?
Oh, the feedback. Is this Iran? Hold on, put my
Are you talking
feedback
about
up.
the press conference where the guy fell
Is
asleep?
this Iran?
Yes.
No.
No.
Maybe. Where is it? It just started back up with no context. I'm seeing white people. This is not Iran. Who the fuck is this?
What does it say in the corner? I can't see it.
It was the Minneapolis feed, and then just fuck. Maybe it. Who the fuck knows? Who the fuck cares? Let's go to this, guys. This press conference yesterday. This is not the angle I watched it at. I want to watch it from this angle, guys.
Brian O'Hara,
Watch this shit.
BRIAN'Hara. I am the Minneapolis Police
Lower
Chief.
the music. Oh, okay, Linda. Sorry.
At 6:51,
I already did.
You got it.
Minneapolis Police
Got
received a 911 call reporting a shooting on the 600.
Fast forward it to where, like,
Or-
this stuff is dumb. We want to go to where the guy was.
Indicates
Well,
that
I'm
there was
showing-
a struggle with the federal agent in front of the
Blah,
resident.
blah, blah.
During the
You shut up. I have a reason for it, okay? So he's
blah, blah.
talking,
federal
he's
agent
coherent.
visited inside of the resident.
right?
Eventually, federal agents made entry.
And then,
That's
Blah, blah, blah.
in a way.
okay, and then what? What?
Look at him!
Look at him. Watch this shit,
Yes,
right?
further.
Just watch the fucking. Watch this shit. Can I fast forward this? Nope. Just watch this. Watch the chief, guys.
Just watch
Don't
him.
give a fuck about the mayor. Watch the chief.
There's
Yeah,
still a
skip
lot
that
that
guy.
we don't know at this time, but what I can tell you for certain
Guys,
is that this is not sustainable.
Huh?
This is an impossible situation that
tired.
our city is
Huh?
presently being
Oh.
put in.
Huh?
And
What?
at the
He's
same
talking.
time, we are
Maybe I should
trying
stay
to
awake for
find
this.
a way forward to keep people safe, to protect our
And I'm
neighbors.
going to start to sway a little bit.
And we're in a
getting a little
position right
tired.
now where we have residents that are asking the very limited number of
Man,
police
Mr. Mayor, you're
officers that we
boring.
have
You're so
to
boring.
fight ICE agents on the street, to stand by their neighbors.
Staring off
We
into
cannot
space.
be
Huh?
at a place right now in America
Look at him swaying,
Yeah.
guys. He's doing the
where we
sleep
have
play
two
too.
governmental
Skirt, skirt.
entities that are literally fighting.
I don't have the ability to share links, but the Savage Rabbit is at Savage Carrots.
Yeah.
one another. Why are we put in this position? We're put in this position because we have approximately 600 police officers.
Suck it
in
up,
Minneapolis.
Buttercup.
Far fewer that are able to work at any
Look at him.
given
Look at him.
time.
Up,
And there are
up,
approximately
up.
3,000 ICE agents in the area.
Up.
3,000. The
Up.
600 police officers that we have are charged
What's the
on
matter?
any
I gotta-
given day
I just
with
gotta look.
investigating crime, stopping an officer in a city. Beyond.
Look at him, guys.
I
Look
want
at him.
cleaning up
Rocking
my
back and
love
forth.
your
Yeah,
time.
oh, gotta pick my head up.
Imagine if that city or that town was suddenly invaded by thousands of federal agents that do not share the values that you hold dear. Play so
Who? What? Are you still talking?
scared.
Oh, now I'm.
No, hold on, guys. Like, I gotta go to the other
All right, let's take
angle.
that presser.
That do not share the
Look at it.
values that you hold dear. Imagine if your daily routines were disrupted. The local cafe that you
So
eat at
funny.
was shut down because they're scared that their own family might get torn apart.
Stare off.
Imagine if schools
those
shut
kind
down
of
and suddenly not a
Look at him.
huge pin
A's
by
Look
Well,
at him. Look at that fucking
taken-
stare,
so-
guys.
Looks confused.
Let's be very intolerable. Stop
Look at it.
brand
There.
of
And then-
chaos.
oh,
And I
there we go.
you're taking in our city.
Look, guys! Oh
And you are
my
not
God.
helping the undocumented immigrants in our
Hold on,
city.
let's just.
You are not.
We don't need to listen to what he's saying. All right,
Mm-mm.
oh yeah, no. Let's reframe it. Get the chief off the camera because he's falling asleep. Guys, it was so bad. Oh, it was so bad. Oh my God, everybody! Like he zonked off for the entire fucking thing until he got back up.
Until he got back up to like
Look at it! Look at it!
questions.
Dude, I feel so
We
bad
were
for the guy.
laughing. We were laughing quite hard.
Oh, it was bad. That was really bad. All right, so we're still on a recess.
Thanks, Miss Kelly. Sometimes people get sleepy because they stayed up really late the last 4 nights because they can't go to sleep.
Hey, no.
Police.
Dude, in all fairness, dude, that that chief of police is fucking tired as shit right now.
Mm-hmm.
Like I'm shitting on him for the press conference. Like you should have had someone else do it if you're that tired. But
sure.
like you can see, like he is physically worn the fuck out.
Mm-hmm. So I got this guy.
Mercado. Yeah, I'm waiting for him to get somewhere because he's just driving around right now.
He's just been driving around looking for him.
Yeah.
Yeah.
Because I'm pretty sure that he got into some shit for what he showed at the ICE facility yesterday.
Mm-hmm.
Yo, if you guys did not see it,
about paperwork.
fucking Gregory Bovino was at the Minneapolis ICE facility yesterday, like boots on the ground.
Kelly, Benghazi Rabbit we're gonna keep it going, but we're gonna slowly start putting everybody over at the Savage Carrots.
Yeah, let me show you guys this. This was Secret's got it up.
I have it up.
Yeah, hold on. Watching yours. So this was from yesterday, everybody.
Is this where he
What?
something about the paperwork or something?
I'm not sure. I don't want to show whatever it may have been, but I want to showcase this part because the chief of Border Patrol, Gregory Bovino, guys.
Right.
He showed up at the facility yesterday. Now, I want to preface this. I 100% support law enforcement. However, we all don't like dirty cops. We all don't like tyrants. But this image that soon unfolds here is definitely reminiscent of Nazi Germany, guys. Just not calling the cops Nazis. I'm just saying the imagery portrayed here in the next fucking 2 minutes it's look at this right here. Fast forward a little bit.
Fuck you, Nazis! Fucking Nazis! Fucking Nazi motherfuckers!
And there's Pavino. Look at this shit, guys. Like, now, like I said, I'm not calling them fucking Nazis or anything. It's just the imagery portrayed was very reminiscent of the Waffen SS back in the day, guys. Like you had your whole line, your whole rank and file there, and then like I'm referencing historical context now, where you had the whole rank and file, and then you had Himmler up there with his dress uniforms, and then you had fucking Bovino show up, and like, bro. You're literally just giving them fuel to call you fucking Nazi. Look at
It's really loud.
And then they go up, they storm the shit. They actually arrested a bunch of counter protesters.
And
Crazy guys.
This is where Rabbit and I don't see eye to eyes, because I don't like any of this. I don't agree with ICE.
Trying to see where's it good.
And MC, I don't know what you mean format.
Boom, boom, boom.
I
Oh,
think that's
company's more important. Go. Have a good day, Kelly.
Bye, Kelly. Bye, Mom.
Bye.
But it's always gonna StreamYards always makes it to where there's a vertical and a horizontal, if that's what you meant.
Yeah, we could set it that way.
Yeah.
Okay, still in recess.
Still in recess.
All right, what's going on in oh, shall we check the flight radar today, guys? Shall we check the flight radar?
The Savage Bunny is not great. What's the Savage Bunny?
Oh, wow. Lots of stuff going on. All right, now let's filter in commercial air traffic.
Oh, the other channel. Yeah. We might also like not stream to Benghazi just so everybody will go over there. What's going on in Iran? Oh, look, there's a lot of people in it. Like, so
These are
yeah, those are commercials.
so yesterday they only had
Yesterday
it
it
to
was-
where Iranian air traffic only, but now there's some like this is Dubai. Fly Red Wings.
And then also too is if you guys are over there and people are over here, you can see the chat from all the streams. here on the screen.
Okay. Still in recess. Bunch of nothings.
I'm looking.
Muggsy, what are you doing, buddy? You want to come say hi to everybody? Lucky boo. He does not want to say hi to you guys. Hey. All right. Yeah, that's right. You put that music back.
I don't think people want to. Let's see.
Fuck.
I know, I'm looking around. What's up, Taipan? Taipan, how are the whatchamacallit? The prices on cattle right now? Oh.
Here we go. Here we go, everybody.
Examine what has been presented and make a decision on how we move forward today. So the defendant's
Can turn the volume back up.
defense's argument and the defense relying upon
Full volume.
in Robertson cases.
Oh, okay.
If there is a showing of conflict of interest under Rule 1.7, then the court should exercise its discretion and require the Utah Attorney General's office to stand in for the Utah County Attorney's Office. Mr. Novak conceded that there has to be a very good possibility of a conflict or showing of a conflict. No authority was given to the standard of proof necessary to satisfy that showing. This court wishes to address the issue of the showing of conflict of interest under Rule 1.7. And with regards to the first question, whether the prosecutor has a conflict of interest under Rule 1.7, the defendant asserts the following facts, and I'm drawing from the motion itself and reading from it. One of the prosecutors on the case has a family member who, along with approximately 3,000 others, attending Turning Point USA at UVU on the day Charlie Kirk was shot and killed. The family member texted the prosecutor almost contemporaneously. I can't speak today. Contemporaneously. I'll pretend I said that word right. With the event, and shared that they had heard the gunshot and that they had run with the crowd and other observations, feelings, and reactions. Thereafter, the prosecutor went to UVU and investigated how far away his family member was to the shooting. The family member had left a backpack when they fled. The prosecutor determined that the family member was approximately 85 feet away from Charlie Kirk when he was shot. In my view, those are the alleged facts that the court must consider to answer the first question. Does the prosecutor, by virtue of his relationship with a family member who witnessed the shooting, have a conflict of interest under Rule 1.7? And turning to that, just looking at my notes, I appreciate your patience. And so turning to defense, if I accept the facts as you have alleged in your motion as true, is there any reason to call witnesses to answer the first question before the court? And before you answer that, I understand that there are other relevant facts that pertain to the effect of the alleged conflict. Those facts would include whether the prosecutor was properly screened from the case, what conversations he had with other prosecutors, and whether the family member's experience impacted the state's decision to seek the death penalty. It is the defense position, as I understand it, those facts may need to be explored through witness testimony. But if we're just talking about the first question, whether the prosecutor has a conflict of interest under Rule 1.7, is there a need to call witnesses?
Yes, Your Honor, I understand that the court is trying to get to the threshold question that we have put before it with respect to who should be representing the Utah County Attorney's Office in this motion. But the answer to the court's question is yes, because it's not just the mere transactional event that this, that the offspring witnessed the shooting.
What?
It is the
Bless you.
evidentiary development will get at.
No, I was laughing.
Again,
Like, what
we
the
were only
fuck?
provided with
Well,
an
like,
affidavit, which was very
The offspring
trying
who
to
witnessed
narrow
the shooting? Is that what he
at
said?
Yep.
communications that happened after that between that offspring and their parent, between that offspring and other family members that may have been communicated to the parent, communications
so
between the parent
confused.
and other people in the office, the impact. Okay, so now I'm going to just say, if I had found out that my child was at an incident where somebody was shot and killed, I would have an incredibly strong emotional reaction, even if they were safe. Okay, so give me a second, okay?
So there.
There was a horrible shooting incident at Brown University a few weeks ago. And I have a child who lives within 20 miles of there, who was in Providence that day. And everybody in our family was really freaked out until we knew that they were safe. And then even when we knew they were safe, the question was, what did you see? Did it affect you? Turned out everybody's fine. But it's not just, oh, I was there, right? And my family member didn't witness.
So they're trying to get a family
Wasn't
member
in a
to
crowd with
testify
3,000
of
people
somebody who
who all
saw
had
the
to
No.
shooting?
run and take.
No, they're trying to say because the prosecutor's child was at the event that Charlie was killed, they now have an emotional response to this event. So therefore, hey, there's a conflict of interest and they can't try this.
Oh, why didn't they
In case
just
there were
fucking
more
say
shots.
that?
They did, but
case there
in
were some
legal
other
Like-
legalese.
harm that occurred.
Oh my
So,
God.
It's
Ugh.
not just the fact that this person was 85 feet away from Mr. Kirk. That begins to, that scratches the surface, if I may, of the the totality of the circumstances, which we think created a conflict of interest. So the answer is yes, and that's why both the parent and the offspring are here and are under subpoena and agreed to be here and agreed to testify. Obviously, it's the court's proceeding, but nobody's moved to quash, and I think it's obvious that that's because we need further factual development. And our reply brief, if it did anything, it communicated to the court the case law, which shows that this is a fact-intensive inquiry and that affidavits are required. And here we don't have affidavits from the parent or from Mr. Gray. We have argument in a brief, but we also believe that testimony from the offspring is necessary, and they're here and they agreed to be here. And they agreed that Ms. Visser could sign an acknowledgement of service of a subpoena. So the very, very long answer to the court's question is yes, definitely. We need to have an evidentiary hearing.
But isn't the defense required to make the threshold showing from the facts that you're asserting? Isn't that where we begin? Not necessarily the state's response, but don't you have a responsibility to show that you've made a threshold showing of what you're asserting would rise to what you're asserting in your motion?
So the state, so the Utah County attorneys informed us that this offspring was present in a crowd, was caught up in the ensuing chaos, heard a shot fired, had to leave their belongings behind, witnessed the trauma of other people. We can't really get beyond that without fact development. And if what the court is saying is, I want you to go sit down and interview people, that's one thing. But if the court's saying that we somehow should have more information than the county has given us, we can't do that without evidentiary development. Okay? We have questions about whether there were more non-recorded communications that we haven't been told about. I think we have a good faith and the court could imagine that a family would talk about such an incident, and it wouldn't just be the text messages that the court has in the exhibit. And I don't purport to say anybody should run their family the way my family operates.
All right, we fucking figured it out.
Natural, which is
Case closed.
Families talk about these things because we want to take care of our kids.
Okay,
Sure
let's not joke
and
about
then
that.
we need to make sure that our responsibilities to the public and to justice are
Especially on the Benghazi
by our
Rabbits
personal
channel.
experiences.
Like,
And I think that we can only
yeah,
get
no.
at that, Your Honor.
Yeah. Next thing you know.
Exactly.
All right.
And that's why, and I think that the state would agree with that, because that's why they provided the court with some affidavits and some fact in the course of argument. So I think that it needs to be fully developed through the very limited number of witnesses that are present.
I understand. Let me turn to the state.
Fuck's sake, that was the longest answer to the
So
most
I'm
simple question.
understanding Your question is, there's two layers here, right? The first layer is when an alleged
Remember, they get
conflict
paid
arises,
hourly. So, I mean, the
does
more fluff they
in this
can
Oh, I
case,
add,
know.
the more
attorneys
money
I
they
know.
make.
have to conflict
Fuck.
the handling of that allegation to another special prosecutor, attorney general's office, right? Your question is, doesn't the defense have to make an initial showing before that first conflict has or occurs that requires that delegation?
Yes.
Okay. My answer is yes. I mean, otherwise we have to have a hearing to determine if another entity has to handle the substantive issue. And then you have to have another hearing to determine if there actually is a conflict. I think there has to be at first
Is Tyler over there asleep?
a showing that there is a basis for a conflict. Otherwise, someone can come in and say, I think there's a conflict without any evidence whatsoever, or not evidence that's credible. I think, and for that reason, I think the court should be able to make this threshold showing based on the affidavit, right? The affidavit and the facts have been proffered. I think there's enough there for you to say, yes, the county attorney's office can handle this motion on its own, or no, this motion needs to go to the attorney general's office, whoever else, to handle the substantive issue of whether or not there's a conflict. I mean, I want to be clear.
New episodes Mondays.
Even after all these years, I never tire of this view.
Your favorite community returns.
Not us, guys.
With
This is
open
Sport
arms
TV.
and open hearts.
Look.
Do you think they're official?
Pay attention.
Hello, Bill.
Hello, Georgie.
We've sure had
All right, let's go
adventures
on.
in these
Hey,
woods.
hey, 14
Hopefully
guy,
we'll have some
wake
more.
up.
And the
Wake
moment
up.
you've been waiting for.
Hello.
Hey,
This is
guys.
Ed playing.
When Calls the Heart. New
Hello.
episodes streaming Mondays on Hallmark
Hello.
Plus on YouTube primetime channels. Start your free trial.
Yeah, this dude just straight up walked away
He's
from the computer.
Fired.
Bruh.
Fired.
Fuck out of here,
Fired.
bro.
Not to determine whether or
Oh my
not the
God,
issue
we
of
missed
whether or not
crucial
there's a conflict
information
should
because of
be
you stupid motherfucker.
I think there may have been a little bit of confusion there, and I'll take responsibility for the question. In regards to the threshold showing about the conflict, so the threshold showing of a conflict of interest under Rule 1.7. So the AG's it seems to follow after in time to see if there's a conflict initially. So in regards to establishing that, defense, and I don't wish to speak for you, but my understanding is you wish to call witnesses to put that evidence on.
Then I misunderstood the court's question. I don't think we need to take testimony in order for this court to make a finding on under 1.7 that
Giggles, you couldn't pay me enough to watch Hallmark movies.
conflict-free counsel should represent the state in this motion. I am not suggesting, and I didn't mean to, that there should be two hearings. That's not what, so if I misunderstood the court's question, I thought the court was saying, do we even need an evidentiary hearing on your motion to disqualify? Isn't it enough for the court to just read the papers? But that was not, was that your question?
Well, and I'll take full responsibility on my question. That was really the push on it, because my understanding is that determination needs to be made based off what you told us in the beginning, that a showing of a conflict of interest, there has to be a very good possibility of a conflict, or showing of a conflict is the very first step before we go down the further road of addressing the AG's office. And so I was alluding to, based off that, does that require an evidentiary hearing from your perspective?
I don't think that it requires an evidentiary hearing, but I don't want to predict or make assumptions about the court's view. I believe that the Utah County Attorney's disclosure to us on October 20th of this situation and our assessment that it creates a conflict
God, this guy
is
fucking
not frivolous.
sucks.
It's not taken for the purposes of delay or tactics. It's a real potential conflict. I don't know what the threshold showing is that
So we're going on how long
permits
just
or
for him to
requires
say
the court to
that
exercise its
the child
at
of a
least 15
prosecutor
authority
is
under what is
no,
now
like this whole motion has
Yeah,
been about
yeah.
one
juxtaposition
person.
to-
Yep.
the Utah legislature changes its code so often. Like we
Good
have to figure out
God.
all the new code numbers, but it's now section 17-68-304, which gives the court the authority to appoint the attorney general in this situation for this purpose. 17-68-304, as opposed to the code section cited in Jimenez. The law is the same, but the code section has changed.
This
But
is
what I'm saying is,
absolutely dog shit. Stupid.
I don't want to predict or gamble with what showing this court thinks is necessary in order
Same
to
here, giggles. I would just like
appropriately exercise its discretion.
start yelling at my attorneys and being like, get
And
to
so
the fucking
If
point.
the court says, I need more, then we should have an evidentiary hearing, because the important thing is to get it right, not for me to bargain on whether our papers show enough. The only thing that we know that we can show in our papers is what we were told and what we were given. And we were given some text messaging between family members and maybe some other people. I mean, the court has that, it's an exhibit. That's all we really have. And so I don't want to just say, oh yeah, there's enough there, and then have the court say, no, there isn't. Because it may be that the court wants to take some permit us to take some preliminary testimony in order to make that decision. But what I really think, instead of starting an evidentiary hearing on a motion to determine if there should be a referral, I think that there's a sufficient showing that there should be a referral by this court because of 1.7, under the court's authority under Utah Code section 1768-304, before we even begin to take testimony. I mean, the fact that Mr. Gray is going to be the first witness we call already, and that the state hasn't moved to quash because it's a frivolous subpoena, or it doesn't have, there's no basis in the factual predicate to
Taipan, the jury
Mr.
isn't
Gray
in there.
about these things, suggests that there's a problem here. But Mr. Gray's office is representing Mr. Gray while also trying to represent the state. And that's an inherent problem. And I understand it's a thorny question. It's what's the showing that's necessary, and does the court have discretion, or is the court compelled to? Is the court going to commit error if it doesn't? That's why I think that maybe some thoughtful briefing is an appropriate thing to do before we start an evidentiary hearing and then realize that we got off on the wrong foot, because there should be somebody else seated at council table when two members of the state's attorney's office, who are members of the prosecution team, are two of the 4 or 5 witnesses in this hearing. So I'm not trying to dance around the court's question. What I'm really saying is,
Wait, the prosecution only has 5
I don't
witnesses?
know that we can be stuck with only being able to give a court a showing based on the evidence we've been given, when all we've been given is a memo that says, this person was there, we don't think it's a problem. They were 85 feet away when Mr. Kirk was killed.
And so
It's okay,
and I
Taipan, I'm
appreciate
not
what you're
either.
saying, counsel, but what I'm trying to determine is,
I am too.
in your regard, in your understanding, I want to address this, the
But
sufficiency
the
of the
jury
showing.
box is
Is it your request for an
over
evidentiary
there,
hearing
like
for you to present to
those
the court
chairs right there.
enough evidence for the court to make that determination, or something else?
If the court doesn't believe that the papers themselves sufficiently demonstrate that for purposes of the motion to disqualify, the state should be represented by somebody else, then the answer is yes, we want to have an evidentiary hearing up until the point where the court reaches that conclusion. Because that would be the only way for us to satisfy whatever showing the court deems necessary. So I'm not going to waive an evidentiary hearing if the court's saying, well, I don't think you have enough evidence here. Obviously, the answer is yes. What I'm really just saying is, I think that based on the papers, the court can say, yeah, this is a significant problem in a serious case that has really, really serious consequences for Mr. Robinson, for the people of the state of Utah, for the victim's family, and we should do this carefully and correctly. And I think the way to do that is to have the Attorney General of Utah designate somebody in their office to represent the county for this limited purpose until the court determines the scope of the conflict. We think the conflict requires disqualification from the case, but ultimately, obviously, that's going to be a judicial determination.
All right. Anything further from the state before the court makes its ruling on this issue?
I just want to clarify, you're talking about the need for an evidentiary hearing in order to determine whether or not the states that the county attorney's office can handle the motion to disqualify?
No, I'm determining it's just an initial showing of a conflict that exists here.
Jesus.
Well, for what purpose? To disqualify the office or to have the attorney general's office step in and handle the disqualification motion?
To disqualify the office.
Can I take a crack at it?
If you wouldn't mind, Mr. Gray, just stepping to the lectern, just so the record
my
picks you up.
gosh.
Jesus
If I could take a crack
criminy.
at it. Basically, I think what you're saying, it's kind of like a Frank's hearing where you have to allege sufficient facts. So that based on those facts, if the court takes that as true, then you would need whether or not there would be a legal basis to conflict it out or find a conflict, right? And so if they don't make that showing, then the court could rule straightway. But if they do make that showing, if what's alleged is true, then we go to an evidentiary hearing. Is that?
Mostly, it's the initial showing of a conflict, and what happens after that will be determined because they're bringing this up for the first time today.
Basically, like a prima facie showing.
This is so
initially.
stupid.
Essentially.
Yeah. Okay. I think that's. Yeah. I'll let you.
No, I appreciate your clarification. Mr. McBride.
Nothing else.
All right.
We're gonna take another
As the court
recess.
said, and I've read the briefing by all parties and
Deny
listened to
it.
the
Deny
argument
it,
today,
please.
And I don't believe a sufficient showing has been made.
Yes.
For the court, just relying upon the briefing itself.
Yes.
And so I can't make that finding based off, well, I would find that that threshold showing hasn't been met based off the briefing. And turning to Mr. Novak, based off that finding of the court, what is your position?
Our view is that if the court has concluded that the briefing does not yet rise to the level of proof that the court should at this time make a referral, then the court should begin to take evidence. And there may be a moment where the court says, okay, I've heard enough. Now I'm ready to make a referral. And we're going to stop and pause.
Whoever's fucking
wait for the
talking
Attorney
needs to shut the
General
fuck
to
up.
engage. And then we'll have to see where that goes. But it may be that we have to finish the evidentiary hearing. But, and I think all of us can attempt to prioritize the portions of our examination so that the court can make that finding as early as possible. I'm just trying to avoid doing the hearing twice. Because right now, it's our view, the state is not being represented by the attorneys who should be representing it. And so if the state's going to come in later and say, well, we want to redo the evidentiary hearing.
Yeah, boot, you literally didn't miss
because the
anything.
state wasn't represented by the right parties. I mean, or by the right lawyers. That's something that we would want to avoid. We want to do this once out of a courtesy to the court and to
Nothing, boot. He didn't conclude anything yet.
Can this be accomplished by proffer?
I don't know what the witnesses are going to say because
Yeah,
they've only given
I
us
don't know.
very limited information.
Because he's asked clarifying
State
questions. Now
elected to
clarifying
give us
questions are like 45 minutes.
In their briefing, some of which is, like I said a few times now, is not sworn by affidavit or declaration. It's in the nature of argument. I mean, there are portions of Mr. Gray's brief, he signed it, where he makes many, many assertions of fact in the course of arguing the legal issues. And none of that is sworn. And I'm not sure that...
hold on, let me pause it. But
And I
to
think-
give you an update, they're saying there's a conflict of interest. The defense is saying there's a conflict of interest in the county attorney's office because the one prosecutor in the county attorney's office, their
Mr.
child,
Gray,
their child
his child
was
is a
at the
witness.
was at the event when Charlie was shot. So, and 85 feet away. So there's enough emotional stress there to be a conflict of interest because the prosecutor went there to see exactly how far the offspring was from the incident. And they concluded it was 85 feet away. So now the judge is like trying to figure it the fuck out.
So I don't think there can be a proffer because I don't know what the proffer is. I know that I have a lot of questions about things that that the court was not told about in the briefing and the affidavits. So the answer respectfully is no, it can't be done by proffer.
And which witnesses are you intending to call today? And I understand you're saying you wish to just put on enough
So,
and focus.
pretty
on
sure the judge just denied that shit.
If I were to grant, I'm just trying to understand the scope.
Well, I think Mr. Gray is the first witness.
Or he's getting
Second
there to
witness-
it. This is getting so fucking juicy.
Parties to the bench, please.
Okay.
I'm gonna run the kids outside for a second.
I'm falling asleep.
This is why I didn't want to cover some of the other trials.
Thank you, counsel. In regards to the question of what witnesses do you anticipate calling?
Mr. Gray, I'm going to get his title wrong, but Mr. Christensen is an investigator with the county attorney's office. The prosecutor who we believe is conflicted off, and their offspring.
All right. Any input from the state at this point?
No.
All right. I'm assuming the next portion that we need to address is your motion in regards to the hearing itself, the evidentiary hearing, whether it's closed or open. Correct?
Is the court looking over my shoulder at
No, I'm
media
looking at,
counsel?
no, at you.
Okay.
Sorry, there is someone behind you, but I was trying to look at you. That monitor's in the way, but I appreciate the clarification.
Chris Ryder.
I can't see over the.
County attorneys
I can't
had
see.
informed us
Can't
of
see over
this
the monitor.
factual issue, and we told them that we thought that
Ugh.
there was a disqualifying conflict. We had an agreement. That
This
we
is
would file
brutal.
Our motion privately, I think is the correct.
I feel
term,
bad for Tyler
so
to just
that
having to
those
sit through
identities
this.
were protected.
I know.
And that was at the request, and we.
At least he's getting out of jail.
We have no problem
Yeah,
with
right.
that. So
You know?
we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so.
Taipan.
And
I love how you had to yell that and then Roman Coliseum.
it is.
Is not being yelled.
McBride has verbalized this very well in conversations and in council. The record is. gonna be
Mistrial, Your
very,
Honor, I
very
couldn't see you
muddy
over
if
the
we
monitor.
Can't have examinations that use
There you go.
names and identities.
Case closed,
It's just
everybody.
gonna be super-
5 things people love.
All right.
Jesus.
Come on,
leaders.
Court
I can
TV.
see clearly,
It's your
like
shit.
this way from top, and then on the bottom, it's
The
magnified.
guy who's
You
there to
can
hit the
see-
button to skip it.
Oh,
he
he's
fell
there
asleep
this
too.
time.
Oh,
He's
he's
there.
awoke. He's awoke.
Deference
How
to
the fuck does
request
Court
of the
TV not have YouTube Premium?
To this date.
Given the extreme publicity and the issues that surround this case, we would ask that this portion of the hearing be closed.
No.
This is
We've had
2
communications with
hours
counsel for the
that
media.
they have
We
been
believe that they agreed to that,
talking about this.
after
They're going to
taking
close the
balancing
evidentiary
test
hearing.
of,
You
the
cocksuckers.
public's right to know and the right to an open proceeding and the privacy interests at issue.
All right. One of my concerns that I have, and is there any other parties weighing?
Dickhead.
I think there may be, Your Honor, both
Your
by
Honor.
event and hearing proceedings.
All right. Well,
Your Honor, this is Jeff Hunt. Can you hear me?
I sure can, Mr. Hunt. Thank you.
Who the fuck is this?
Your Honor, thank you for the accommodation and courtesy to allow us to appear remotely. With me is my colleague, David Ryman. We represent the Deseret News, KSL, KUTV, and other news media. We would like to speak briefly to the closure issue, if that's okay.
Yes, please.
I'll hear from you.
Please.
We did meet and confer with counsel for the state and counsel for the defendant concerning closure. And counsel has explained that they believe it would be impossible to conduct this hearing or even portions of it in open court without causing prejudice to the privacy and personal safety interests of the family member witness involved.
Oh,
They've told us
fuck.
they believe it would not be feasible or practicable to approach this on a witness by witness basis or an issue by issue basis, because they believe the names of the prosecutor and the family member would be used throughout the examination of witnesses.
Oh, come
So we have no reason to
on.
doubt the statements and representations of counsel, and in reliance on those would not be objecting to closure of the evidentiary hearing on the disqualification and the referral issues unless the court has a different view and believes that we could parse this on a witness by witness or an issue by issue basis. That said, Your Honor, we understand that counsel for the state and the defendant have agreed to review a transcript of any evidentiary hearing
Giggles,
and
he's
make
their
limited and
attorney.
appropriate redactions so that a public version of the transcript could be released. And with that, there are just a couple other brief points I'd like to make. First, we think that this should be the rare exception to conducting these proceedings in open court. There's a strong constitutional presumption of open and public court proceedings, and of course, enormous public interest in this particular case. That openness and transparency is an institutional value that serves this court, the participants, and the public well. The facts and circumstances of this particular motion, given the fact that it concerns a family relationship of the prosecutor, makes it a very extraordinary and unique situation that we feel, given the representations made, can justify the closure. Although we do believe in most cases, just the fact that a motion implicates a witness will not be grounds for closure. Second, we just wanted to get on the record that we believe that release of a transcript is not an adequate substitute for the ability of the public and the press to attend and view the proceedings themselves. For this particular evidentiary hearing, that may be the only practical mechanism for the public to obtain some information about the case. But again, we would expect this would be the exception and not become a regular practice. And finally, Your Honor, it's our position that any oral argument on the disqualification motion or the referral motion should be conducted in a public hearing. As this hearing itself has shown, a lot can be done and argued without disclosing the names of family members or the witness at issue and jeopardizing those interests. Counsel can refrain from identifying the prosecutor or family member to protect the asserted privacy interests. And we have experienced counsel. They can be mindful of that issue during oral argument, and it's not unduly burdensome for them to take those steps. And any burden would be greatly outweighed by the public interest in learning more about the motion and having at least an open argument. So we do believe that the argument, and I understand the argument will be made at a later date, not today, but that should be done in open court. That's all I have, Your Honor.
Thank you, Mr. Hunt. Anything further from the parties?
Oh my God.
As to the oral argument, it is
Oh
our,
my God.
it is
I
our request that it be
can't.
closed, and the reason why is that we're not perfect. Names slip. It's happened in trials. It's happened in arguments before, and I'm concerned of the risk that that could have if one of the parties, one of the attorneys, were to slip and identify those who ought to be protected. With that said,
You don't want your kids out there in the public, even though you're a public official.
Action should an inadvertent mention of a name be made.
Thank you. Counsel, one of my biggest concerns is I have to make findings of fact that are very specific. I can't redact my findings when I issue an order. And I will have to cite to the relevant facts. And quite honestly, the name of the prosecutor is a relevant fact. I can't simply glaze over that and make an assertion. It's important because it relates to various factors that you may address and which has been brought up in briefing. And so this court is going to deny the request to close the hearing.
Yes!
As it relates
Yay.
to, and I will take
Yes!
this motion witness by witness. I understand that there may be a witness
Big win
that
for everybody.
this is applicable to, and the court will entertain that. But because it has to make findings and has to cite to the facts, I need to be able to do that. And since I'm going to do that anyway, which I will, I'd rather address it in an open court. And again, I will entertain any motions, witness by witness, that are going to be called and be respectful of that. But going to Mr. McBride's point, you both have that duty. It's in regards to how you present. And if you're talking about a name that needs to be protected, that's on you on how you speak. I can't.
Fuck yes.
It seems
This guy ain't
inappropriate
playing no
to create a
fucking game.
safeguard to prevent you from making a mistake on accidentally saying a name. That I don't believe that would be a proper reason to close the hearing just for that. And I understand the pressure, counsel. I know it's difficult, but I cannot accept that as reason to close the entire proceedings for the evidentiary hearing portion. But again, as the witnesses are called, I will entertain the motion whether to close the hearing per witness, and we will address it as
good, as you fucking should.
Mr. Novak.
Chat, this is huge.
Yes, Your Honor.
With that, how would we like to proceed? Well, first, is there any clarification needed on this court's ruling as we're proceeding into the evidentiary hearing?
Fuck yeah, chat, this is huge.
Are you going to entertain motions to close at the outset of every witness? Is that what I understand?
If the motion is made, yes.
Oh, hell yeah. Case by case basis. Chat, this is huge. We just got a big win.
Yes.
Yep, exactly, Giggles. Exactly, Giggles. Fuck yeah, Judge. You ain't playing no bullshit. First Amendment applies here, bitches. Fuck yeah. This is big, guys. The state just tried to shut us the fuck out, and the judge denied it. Fuck yeah. All right, Secret. That was worth the 45 minutes of bullshit.
You mean the 2 hours and 10 minutes?
Well, just talking about because the whole thing was about the offspring, the child, and they didn't bring that up before until after recess. So that was worth sitting for listening to that dumbass talk for 45 minutes about the offspring being 85 feet away. Yes, Giggle says, so attorneys haven't been doing their job is what the judge, basically. He also said that before the recess because he said that you had a week notice about this and you're just now bringing this objection.
Looks like I'm off. Would it be easier just to go into a brief recess? I don't want to feel rushed. You have obviously important conversations. So it's the court's intent to enter a brief recess to allow the parties sufficient time to discuss whatever you need to discuss.
Motherfucker!
Yeah, and it's still in recess.
Right now. and asking you to reconsider that.
Did they?
motion.
Because I'm not
No.
watching it live.
Because,
No, never mind. Don't listen to
courts,
me.
The Supreme Court of Utah, appellate courts refer to witnesses by their initials all the time. In our pleadings, we often refer to witnesses by their initials. In Supreme Court of the United States opinions, witnesses are referred to by their initials. And that's because there's a privacy interest. In this case, I don't think a privacy interest could be greater. This case has polarized the nation in many ways. And there have been death threats made against other witnesses. There have been death threats made. My understanding is there's been threats against counsel. Our offices receive
Provide it.
threats. Doxing is a real thing. You know, finding people online, harassing them online with the technology that we have now. It's not that hard to find out just about every detail about a person through internet searches.
Exactly. So we don't need your. We can find out this shit right now, bro.
Programs that do background checks. And we are extremely concerned that we will have
Look, this is the state trying to come back and get it.
Be subject to death threats, to harassment, to doxing, to all of those things that can be avoided. We're very concerned that that will happen and happen to this person for no other reason than this person's father.
Her. He said her.
Fucking idiot. Got him.
He said her.
Got him.
He said her.
To her, those
He said it again.
There it again.
I think it's by referring to substitute names like we have in the public.
All right, that's all we need to know.
So, Your
Let's
Honor,
start doing some digging, chat.
Just really ask you to please reconsider your opinion. There's a stipulation from.
Nope,
the media.
you just
the
fucked up.
daughter of-
Portion of
It's the daughter of Mr. Gray.
I think the court in its ruling can refer to the prosecutor as the prosecutor. I think it can refer to the child as adult child. I think that would be adequate. I think in a sealed record, there can be references to names. That would be my request, Your Honor. I am.
Oh, you moron.
I can't ask more adamantly than I am.
To defense.
Wow. You just doxed
We
her,
take
bro.
no issue with anything that counsel has said. That's why we completely deferred to the state attorney's, the county attorney's initial request that all of the briefing, as much as possible, be under seal and then redacted.
Thank you. One of the points that when I was considering this as a potential issue is that both parties filed a public version of your motions.
Right.
And you used a mechanism to convey that same information. And then I understand that that makes it tricky, but
Come on, Judge.
it
See
was the
through it.
choice of the parties to do that, to publish those public versions. And the court is fine in regards to particular witnesses referring to those terms that were used in the motions. But this court does not agree that the entirety of the evidentiary hearing needs to be closed.
Yes.
And it is a very broad approach to a narrow issue. And I understand and I respect the concerns made by Mr. McBride. And I understand that. And the court is willing to go witness by witness. If you feel that a particular witness, that needs to be closed, the court will entertain that. I understand the issues of safety, and the court feels the urgency and the importance of that has been stated. But this court cannot find that the closure of the entirety of the evidentiary hearing is proper, given the motions that have been filed publicly online. And I have to leave it to counsel in deciding how you present the evidence, how you state the names. I'm willing to abide by the format used in those public motions, but this court denies the request to close the evidentiary hearing. And again, we'll take witness by witness a motion if that particular witness needs closure that particular witness's examination needs to be closed.
No. Yeah. Yes. Chat. Can we get a fucking hell yeah?
If the court's ready to
Fuck
begin the evidentiary hearing, we would call Jeffrey S. Gray as the first witness.
All right.
If the court wants to take a little break.
We're going right into this shit.
Courts can move forward. If parties need a break, I'm happy to give a break. I know it's
I'm
switching gears here.
literally, I'm like watching a football game right now, chat. This is getting good. We're
In
going
fact,
right
let's go
into
ahead and
this
take a
evidence.
brief break.
No!
We need to relocate our court reporter, so this is a natural spot to take a break.
Fuck.
Absolutely.
Don't fucking do it.
Hold on.
Keep the cameras on. All right. All right. So we're going to go right into this evidentiary hearing, ladies and gentlemen. Fuck yeah. Whew. They tried to cuck us. They tried twice. The judge said,
The judge said from the beginning, from the very first day, he was like, it is going to be open to the public.
Fuck yeah. They tried, though. You all just saw it firsthand. You saw the state try. Oh, we're getting death threats. Oh, I don't want my family to be doxxed. Oh,
Okay,
the
wait,
internet's...
I muted you because the courtroom, I want to hear what they're saying. Yes, Boot. They're
Shut up! I want to hear the court.
Reporter. Court reporter.
Right? Think of the children. My children are gonna be doxxed, even though I'm a fucking county attorney.
That courtroom's not even full.
Drive out there and get in there.
That's what I said. Did you not see what I wrote?
Yeah, no, I said it. I saw it.
I was like, I should cruise up there.
Just wear some fucking aviator sunglasses in the background.
Right? Wear a hat. Well, we just gave away our plan.
Oh well.
They're going on break. Beep. Court is in recess. Fuck off, Boot. Boot, why are you so mean to me? Whatever did I do to you?
Oh, we got stereo audio now.
All right, court is back in session.
Fuck yeah! Oh, we're taking
Counsel?
a break. Shh.
Yeah.
I believe the exclusionary rule is being invoked.
Yes, Your Honor, we'd ask the court to exclude all witnesses during the testimony of other witnesses.
All right, and to the state, any input?
We agree.
And at this time, would it be convenient to just take a brief recess?
Yes, please.
You have to move the cameras, I
All
think.
right, it's 3:20. How about we come back at 3:30 and resume on the record?
Sounds good.
All right, court is in recess.
Ah.
All right, so thankfully that was a few minutes ago.
Oh, geez.
What the
They
fuck?
probably have to move the cameras because they're all pointing directly at the jury. Hello. Wait, okay, so here's a little something I because I was, falling asleep. But here's some. Got this.
What the fuck?
Yeah.
Did he just?
Going for the baseball.
No, that's not real.
Yeah,
That can't be real.
It is.
No,
Yeah.
it's why does it have the Sora icon on it then? That's fucking fake, bro.
Oh, okay. All right. And then I found this.
Let's see. Now I'm looking up actual fucking news stories. Make sure. Oh yeah, no. That's not it. Yeah, no, that was fake as shit.
Oh. All right.
I mean, it even had the icon or the watermark for the AI.
I don't know. Whatever. Never said I was smart. What else do we have?
We need to make some new memes.
Yeah, what do I have? Let me look at my notes. We were on DirectD last night.
Oh, we were? We made it?
We were. Yeah, you want to see?
Sure.
Okay. Hold.
Man, we get featured in a Chris Ryder live stream and then in a DirectD. Oh my god. We're moving up.
I got yelled. I got yelled at. But whatever.
We're moving up in the world then.
Yeah. I guess I should say not exactly yelled at, but I did get kind of get a little punked, which is okay. I'm all right with that.
She got punked.
I'm okay with that. I'm okay with that. Oh, actually. Actually, they're not edited. So I can probably just go, except I need yours, your live. I'm gonna find your live. Need the boot clip? What boot clip? Oh, you know what? I can't get onto D's because he took his lives down. The heck was that?
So those assholes fucking with us over at Court TV.
Oh. So we're gonna have to go with. That's what I was gonna do today was edit these.
You should be coming back here any minute now from the recess. Because it's been 10 minutes. All right. They should be coming back soon, you would think. Don't say you're going to take a 10-minute recess if you're going to take a 10-minute recess. It's interesting that they're starting this trial on a Friday afternoon. 100% Taipan. Hey guys, I should see how long it takes you to realize that she's muted. What?
I know I'm muted.
Oh, okay, it only took her 5 seconds, guys.
No, I knew I was muted.
It only took her 2 seconds, guys. Hooray!
I think we'll do this stuff after this.
Yeah. It'll give it time to prepare.
Yeah, when I steal this speakeasy. I hijack.
Fuck you say?
I am hijacking this.
I'm gonna change some codes around on my locks and shit. Get some defenses set up. But go prepare for battle.
It's okay. You can put everything.
She revealed her
in your-
plan. She fucking
No.
revealed her plan, guys.
Because I took thumbprints from you. So no matter what you do. How did you mute? Did you put a sandwich on your mic? Oh. Yeah, I got a spanking. We'll play it later. I mean, you have to all come back. Yeah, I thought he was going to do a live today going down to the courthouse. Yeah, that didn't work out, did it? Shocker. Look at me. I'm so getting stuff in order for when I take over. I take over. They won't let him in with his cheesy poofs. That's Sweet Pea. Remember, we have two. We have Sweet Pea and Cupcake. Sweet Pea and Cupcake. Women rule, men drool. Yeah. That's right, giggles. That's right. What else did I have today? Trying to look back.
So much for this 10-minute recess.
I know, right? We should have just said. Oh, you know. So, do you guys remember this? Let me find it. Hold, please. Oh. Is it this one? Yes. Okay.
You better show us what you're doing.
All right. Any of you remember this?
You, your family, your kids, everybody would be safe. Your brother's the one
Do
that
you
puts them
remember
at risk.
this live
But they
from
beat it
Killa?
into your head so much
That he went
you
over
think
this video,
that you need them in your life for whatever fucking reason.
right?
Your family's sitting there manipulating you, telling you you need to forgive your brother if you want to get better.
So I thought, and that's perfect of what I wanted to bring out, is that Killa was saying that the family might have been manipulating her. What if D is manipulating the family?
Yeah, that's a good one. Good theory.
Yeah. Thought about that. I was like, wait. Because he's such a good manipulator. How is he not? He could be manipulating his family. I still need to find out what exactly the stipulations of his registry are. I think I was talking with Taipan about this. Or Giggles. I think I was talking with Giggles. Is that his stipulations for his registry? Like, can he be around? Can he be around only his children? Or can he be around family? Like, what are, like, you know, what are his stipulations? Yeah, he was convicted in Ohio. Yeah. Several generations. I don't know. But I want to find out what exactly the stipulations are when it comes to like being around children. Have you guys all what do? Check the registry and see if there's any that live near you. Yeah, him and her both said it in the video. But he never said who he was family member hurt by. I know that he said that he lost his virginity at, you know, to a 19-year-old, which that, I mean, for a dude, wouldn't that just be like, hell yeah? You know?
Like, fuck yeah, dude.
You know, like, so, and he says that's the reason why he became addicted to porn and, you know, stuff like that. So, I don't buy it. I don't buy it. And it's been said many times amongst the YouTube streets is that once a PDF, always a PDF. So.
Well, he said in his own words, he did it to multiple people.
Yeah. Multiple victims.
He only got charged. He self-admitted he had multiple.
Sorry, you're gonna have to go back because I accidentally kicked you off.
He bitch. D admitted that he had multiple victims, but he was only charged for one. Does anybody catch that?
Yeah, exactly, Giggles. How old was he? I think he said 14, maybe 15, something like that. I'm not sure. But he said she was 19. So, but I don't know a dude that would be like, oh my god, she like SA'd me. He'd be bragging to his buds.
Damn right. That's a fucking achievement. He get the Teenage Achievement Medal for that shit.
Mm-hmm. Oh, I'm sorry, Giggles. Oh, I know what I wanted. Let's see.
Dude, it's been fucking 25 minutes for this recess so far. He was like, we'll be back in 10 minutes. He lied, chat.
How long does it take for someone to smoke a cigarette? Okay.
25 fucking minutes.
Jeez. Okay. Okay, everybody. I just want you all to know that I found Todd in high school.
Oh, God.
Uh-huh. Ready?
No,
I did. I did.
I can't see it.
Hold
What
on.
you talking about?
It's coming.
I don't believe you.
We're dead. Just me. What do you mean? Get back to the library. Keep doing it on.
I wanna be an Air Force Ranger.
That's son of a bitch.
Before the day I die, there's 5 things I want to write. My soul, automobile.
G.
Be an Air Force Ranger.
Hey, everybody. Muggsy's here. Muggsy,
Even
wanna say hi?
then, he wanted to be an airborne ranger.
Muggsy, do you want to say hi to everybody? Okay. That's all you guys get is he licked the microphone. So it's a very good hello from Muggsy.
Still haven't made my meme.
Santa, do you want to say hello to everybody? You don't? Because everybody sucks? Okay. All right, still in recess. The Secret's going to have control of the show.
That's really good, Giggles. So I wanted...
Oh, here we go. Put it back up. Put it back up. Put it back up. Put it back up. Put it back up.
Madge, the hands.
Mr. Robinson, we filed today a motion to be heard in the future about excluding cameras in the courtroom. And one of the issues that's reviewed in that motion, which of course the court hasn't had a chance to look at it yet, is the cameraman's repeated violation of the portion of the decorum order which requires that the camera not focus in on Mr. Robinson's lips to allow a lip reader to translate confidential communications between counsel
It was
and
only
Mr.
the
Robinson.
shackles.
And that order has been violated in the past. It's been used by the media to interpret falsely the content of conversations between Mr. Robinson and his lawyers. And it happened again just while the court was in session. I have the clip and I'd like the court to look at it to see if I'm correct.
Oh, God. Here we fucking go.
On Mr. Robinson's lips. And it's going to allow the media to offer the same sort of false narratives they have in the past. So with the court's permission, I'd like to present that to the court.
Well,
Oh, my
Mr.
God.
Burt, is it this is the violation, or is there anything else? I want to make sure I hear your argument and view the evidence in its entirety. And so if there's anything else, I want to consider it all at the same time.
Yes, and for purposes of the motion I'm going to make to the court now, which is to either exclude the camera for purposes of this hearing, and of course the court will take up the issue with regard to future appearances when the court considers the motion, or in the alternative, to order the cameraman not to focus at all on Mr. Robinson. And so I think for the purposes of that motion, the court needs just to look at the clip that we would proffer to the court as showing that there was a clear violation of the court's order.
Thank you, counsel. I appreciate that. Before I turn to that, I'll turn to the state if they wish to weigh in the request.
I think it raises a legitimate concern. I think the court ought to consider the evidence that the defense counsel has.
All right.
It's very brief.
I appreciate
We have it on a phone and the court can look at it.
And have you shown that to
That's what we
the
just saw.
other parties?
I have.
Okay,
Right?
thank you. I appreciate that.
Of him
Pretty
You may
laughing.
approach it.
Yeah. They're fucking mad. They're mad.
But I didn't see him say anything. Did
Well,
anybody?
it's the fact that there's a court order.
Oh.
What is the length of the first
They're
video?
fucking mad as shit right now.
And do you want the benefit of the record to articulate what this first clip shows?
I think the clip shows that the camera is zooming in the first clip on Mr. Robinson's lips as he is trying to communicate with me sitting next to him.
Thank you.
If I may reapproach with the second video here.
Yes.
And it's the court TV camera. Court TV.
It looks like.
And Your Honor, the second video is a clip from a court TV posting showing Mr. Robinson's lips moving as he's attempting to speak to Ms. Nestler. And Your Honor, one last thing I'd like to add if I could, which is I think the court very correctly and very cautiously admonished the cameraman about your December 23rd order before this hearing began. And he said he understood the order. And I think the order is very clear as to this lip reader provision. And I can elaborate further why it's damaging, but I think it's obvious to the court if the media is allowed to interpret the conversations between counsel and his lawyer, it creates all sorts of problems in terms of Mr. Robinson's right to a fair trial.
Thank you, Mr. Burt.
Thank you.
Just
the chat up
one more question.
on
I
the court
apologize.
TV.
Just for the benefit of the record, and
Hang on a minute.
from your position, citing to the standing decorum order, the violation itself, so we can connect it all from your arguments.
Yes, Your Honor, I forget the paragraph, but there is a paragraph in the court's latest December 20th. And it's been a feature of every decorum order. I think we're on the third one. But from the start, the court has prohibited zoom-ins to allow lip readers to interpret what's being said between counsel and the defendant.
And finally, I think you led with this in regards to the sanctions being requested. You cited to the court sanctions, and then there was a second one referring to, and I want to make sure I wrote it down right, because
Sure.
Something along the lines of not showing Mr. Robinson at all. Like, I want to make sure I understood that request.
Sure. The request was either to exclude the cameras for purposes of this hearing in its entirety because of the violation and because we can't be assured that the cameraman's going to comply with the court's order. The second request is if the court is not going to exclude the cameras, then it should, at the very least, order the cameraman not to shoot any footage of Mr. Robinson, that the camera should be focused on the court and the witnesses, if the court permits that, but it should not be zooming in on
Oh,
Mr.
they're so mad.
His demeanor, his
They're so
conversations with his
fucking mad.
lawyers have nothing to do with the
Why?
newsworthiness of this case. And what it's allowing is very prejudicial information to be leaked to the public through these lip readers and body language interpreters. And it's creating massive prejudicial publicity for us. So that's the request.
Thank you, Mr. Burt.
Thank you.
I'll hear from other parties if they wish to be heard.
Yes, Your Honor. Michael Judd on behalf of the media entities. I want to take the court back to that specific paragraph of the decorum order because I do want to make sure we're on the same page about this. It's the second sentence of paragraph 48 of the decorum order that I understand is at issue here. It does say no visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel, at counsel tables, or bench conferences with the judge. The zoom in language that you have heard referred to previously doesn't fall in that sentence. The zoom in language comes in the next sentence, which says no one may zoom in on anything on counsel's table or the bench to identify any writing. So those are two separate things. The first that we learned about this was during the break. I briefly reviewed the two videos that the court has reviewed. I understand that those were 9 seconds and 5 seconds long. I identified the provision of the decorum order that I believe applied here, spoke to the pool cameraman about that, ensured that the rule about capturing conversations involving counsel at counsel's table or at the bench so that they may be decipherable by lip readers was an important provision in the court's decorum order, that it should be followed. I understand that the cameraman understands that rule, that any capture of those conversations was inadvertent. I understand the concerns raised by defense in this case about potential prejudicial effect of something that is intended to capture conversations. I don't believe that that's what occurred in this case. I believe that the court's order should be understood and applied as written and done so strictly. But I don't believe that there's been a violation here. We've been now on the record for 3 hours. I believe that the total length of the two videos that were shown to the court were 14 seconds long. Whether or not either of those conversations rises to the level of capturing the movement of somebody's lips so that it can be decipherable from a lip reader, I'm not in a position to judge. But I can assure the court that the media is aware of that provision, of defense's concern about the potential violation of that order, and that they will take that seriously. That's already been raised, already been discussed. As far as the remedy sought here, I think that excluding all cameras from the courtroom for this important part of this important proceeding would be broader than any sort of remedy would be necessary here, as would the direction that the cameras not show Mr. Robinson in any way. I understand that potentially any shot on a still camera, on a video camera of a defendant in a criminal case could potentially be twisted or used by some to try to impute some sort of thought or some sort of idea. But I don't believe there's anything in the court's rules. I don't believe there's anything in the ruling so far to date that suggests that the way to address that kind of concern is to say that a defendant, a critical figure in a case like this, and one that the decorum order clearly allows to be photographed and videoed, be kept off camera altogether. The media continues to take this seriously. Before every single hearing, we speak about the decorum order and what it requires. We recognize the importance of doing it and that there can be consequences if that's not kept. The media understands and hears that, and do not believe that any further reprimand or any sort of further exclusion is necessary here.
Thank you. Well, before I turn to you, I want to turn to the stage. I want to give all parties an opportunity, and then that allows you to respond to whatever they say.
Interesting.
The problem with that explanation, that's the same thing they said last time on December 11th. And on December 11th, there was an situation. Lip reader, I can pull up for the court what the electronic media did with the prior violation. They hired a lip reader. The lip reader purported to derive a confession from the incident, and they posted that. It's still up there.
So
So it's great that they apologize, but once this kind of damage is done, it is irreparable.
Your jury
And we
isn't
can't
supposed to be paying
continuously
attention to
have
the media. Are they
violations where the
sequestered?
media gets up and does this mea culpa. And they just continue to do the same thing. And I point out to the court, this is the same pattern that happened in the Korberger case that's discussed in the motion we filed today. And eventually the court there
Can't there be
had to
lip
order
readers
that
in
all
the
coverage of Mr.
yeah, they
Korberger's
can't
face
see Tyler
was prohibited.
where they are.
And we attached that order to the motion that was just filed with the court. And I understand the media's desire for dramatic coverage. I understand how
Dramatic
they want to incriminate Mr.
Dramatic?
Robinson. But
How did
that
they know I
process
was
is
so
supposed to happen in a trial, not in the media. And it's a serious violation. It's one that the court should not just blink away and say, I accept the apology, especially after the court was so clear this morning. Calling the cameraman up, asking if he had read the December 23rd order, and his response was, I'm good to go. Meaning he had read it, and presumably he read that provision about zooming in on lips. There's no excuse for it. The court should take some action.
Thank you, Mr.
Thank you.
Anything further from any of the parties before this court makes a ruling on this issue? That's
Oh
before.
God, are we about to get an
I just want to
admonishment?
make one note, Your Honor. Those clips that I
Are we
showed
gonna
you
have
are
another
just
break?
small portions
Probably.
of much longer footage that was available in the live stream. That was just what we needed to compartmentalize to get it to Your Honor, but it was a much more extensive period of time.
All right, I appreciate this being brought promptly to the court's attention. This is an important issue, and the court takes it very seriously. As it relates to today, well, first,
TV's gonna get thrown
as we
out.
put on the record
Probably.
very clearly that there would be potential consequences for any violation of the court's December 23rd, 2025 standing decorum order. For the first part, well, and I've also had a chance to view the two clips that was presented. It was shown to all parties. The first appeared to show an attorney and Mr. Robinson speaking for about 9 seconds is what my memory showed, tells me, reminds me. The second clip was for about 5 seconds. I believe it was from a slightly different angle, but it also captured that. And in both instances, I could see Mr. Robinson's lips moving. And I don't remember about the second clip, but I believe in the first clip, it also showed counsel's lips moving, but notwithstanding, that was in place. I also refer to a statement made by the counsel for the news media, and going to, it is paragraph 48, and I will read it in its entirety. No audio recording is permitted of the conference involving counsel at counsel's tables or during bench conferences with the judge. No visual recording is permitted of a person's lips so as to be decipherable by a lip reader during conferences involving counsel at counsel's
We may
table
lose
or
the
bench
fucking
conferences
video,
with the
guys.
judge. No one may zoom in on anything on counsel's tables or the bench.
It's gonna have to come from an independent source now.
Now, in regards to the zooming, I know there was a
No, we may lose
representation.
cameras
and
entirely
it's easy
for
to,
this- for
as
this
you're reading,
part.
to kind of combine it, but I'm not finding that zooming in relates to the lip reader portion, but that's not material. I do find that, and I'm not a lip reader, so I don't know what the standard is for lip reading, but I do note that 9 seconds in that first clip, one could see his lips moving, and it is a significant time for, as it relates to this particular issue. It wasn't a passing shot. It was focused on these two persons. And so I find that the decorum order, as it relates to section paragraph 48, as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader, I find that has been violated.
No.
In regards to the second clip, 5 seconds, where it shows Mr. Robinson and I believe one of counsel that I was able to view Mr. Robinson's lips moving. It wasn't a passing shot that it just so happened to capture. It was focused on them. I find that that is a violation of paragraph 48 as it relates to no visual recording is permitted of a person's lips so as to be decipherable by a lip reader. Turning to the next section, finding that the violations have been shown as the court has reviewed the purported evidence of these two violations, I turn to the sanctions. Previously, I stated that under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. I find that applying this sanction would be disproportionate to what the conduct was in those two clips. And the court notes that it is the court's discretion on whether to apply it or not. I find that the court will not issue this sanction. In addition, the other sanctions the court stated earlier today, in addition, the court may impose the following remedial measures if warranted. Immediate suspension of video transmission of the hearing, with proceedings continue only on an audio-only basis for this proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for the electronic media coverage of the court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter where the court determines such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. The court also stated that before making a decision, it would allow counsel to make argument or statements, in which the court has done, and that the court's actions are not intended to have a chilling effect on the open and transparent courts or on responsible news gathering, and that the court is fully committed to the presumption of open proceedings under the applicable rules. That being stated, and as the court was listening, Mr. Burt has suggested that one of the potential sanctions is that for the camera for the remainder of the hearing, and not to show Mr. Robinson at all as a sanction for the remainder of today's hearing.
Yes, please do that.
And so the court considered that as well. This court does not wish to make a disproportionate decision on the
don't be a
actions, and
fuckface,
it does
Your
know
Honor.
and does not minimize the violation. Therefore, this court will take up the suggestion by Mr. Burt that during the remainder of
thank
this hearing,
God,
the camera shall not photograph Mr. Robinson at all, and that will be the sanction of this court. I will allow the pool camera operator to reposition the camera to adhere to that.
Dodge the bullet on that one, everybody.
So I'm going to ask you to come forward because I want to make sure that's even a possibility. And again, I don't mean to put you on the spot. I'm simply, I don't want to set anyone up for failure. I don't want to make an order, and if it's not possible, then further sanctions could apply.
They're embarrassing.
And I recognize
the fuck
that
out of this guy.
This isn't an
it wasn't your
admonishment. He's getting
anticipation to
admonished
be
right
on your
now.
own camera. But as it relates to not showing shots of Mr. Robinson for the remainder of this hearing,
Yeah, this guy's a G.
what are your thoughts?
I can do that. From where I'm positioned now, I can shoot this lectern, I can shoot the bench, and I can avoid the attorney tables altogether if that is what is desired.
All right. Do you need to do any repositioning of the camera to accomplish that? And I'm willing to give you that time to accommodate that.
Nope, we're good.
I don't want to set you up for failure.
We're Gucci, Your Honor.
Given what's happened.
I like this judge.
What are your thoughts?
No, I think the position I'm in, I am okay to avoid the attorney tables at this point and just shoot, this forward part of the courtroom.
All right.
Fuck yeah.
Thank you.
Fuck
All
yeah.
right, turning to the parties, any clarification needed about the order of this court and the sanction that is imposed?
Yeah. I would do
Hide
this.
your face, bro.
I only
Hide
have
your
one. It
face.
sounds
Yo,
like this
you're
issue
good,
is
bro.
specific to
We
video
fucking
coverage and
yo.
that,
Take the
the
admonish for
order
like a
not
champ,
to
bro.
take any imagery of Mr. Robinson would not apply, for example, to the still photographers. Do I have that correct?
Well, I'll hear from the parties before I offer that clarification. Do you wish to weigh in on that
This
issue?
is great. Let me hear you argue
Just to
again.
indicate to the court that one of the problems is not just with the audio, with the video coverage, but most of the coverage is not covering the proceedings so much as close-ups of Mr. Robinson and comments about his demeanor.
Oh
So
my
if they catch him in
God.
a moment speaking civilly to his attorneys and he happens to smile, that then is twisted into evidence
my
that he's
God.
some sort of a remorseless killer. So that applies to the still photography as much as what's going on with the video. So we'd ask the court not to permit still photography, at least for purposes of today. And I think after the court sees the motion,
What a
we'll be in a position to talk about the future. But I think for now, that's our request.
Thank you, Mr. Burt.
Thank you.
To the state.
Nothing further, Your Honor.
And any other inputs?
Oh, please. Please give it a
This
rebuttal.
court narrowly tailors its decision as to the violation, and the violation comes from the camera, the pool camera providing live feed. It doesn't come from the photographer. The photographer is the still, I don't know what the exact term is in this moment, it is eluding me, but the person who is operating the camera to take still shots is under the same requirements for this decorum order. I am not going to sanction them because what was before me with the 9-second clip and the 5-second clip doesn't apply to them. And so I'm going to limit the sanction as it relates to the poll camera photographer, again, recognizing that the standing decorum order applies equally to the still camera photographer. Thank you, counsel. I appreciate you bringing this to the court's attention and
Yeah, thanks for
the
wasting our
seriousness
fucking
and
time.
professionalism that you presented this to the court. So thank you to all parties. And
This is how you know he's
again,
got
to the
shitty defense.
camera operator, do you need time to test out to ensure that there is any inadvertent capturing? I'm willing to do that. I just want to make it clear as day that Mr. Robinson is not to be captured in a sweeping shot in any form for the remainder of this hearing.
Just say he can't be on camera.
All right. All right, counsel. With that in mind, how would you like to proceed?
We'd ask the court to, and the clerk to swear in Mr. Gray.
Mr. Gray, if you would approach and stand before the court clerk to be sworn in.
You do solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Mr. Gray, if you'd like, have a seat. Usually we have water bottles. If not, there's one right here. All
right,
And
this
Mr.
is
Gray,
the
I'm
guy
sure
whose
you've heard this
daughter
before, but
was
if
at
you
the
could position the
fucking
microphone
event.
close to you, just to ensure that the record picks up your testimony today. Thank you. Mr. Novak.
May I proceed?
Yes.
Thank you. Mr. Gray, how long have you been associated with the Utah County State Attorney's Office?
3 years.
Okay, and was it 3 years ago that you were elected to be the chief prosecutor of that office?
Yes.
All right. And had you ever previously been associated with the Utah County Prosecutor's Office in any other capacity?
I've defended on criminal appeals. I was a criminal appeals attorney for the state of Utah for 23 years. So I represented the state of Utah on those criminal appeals, which would include Utah County.
Okay. And did you ever have any professional relationship with the Utah County Attorney's Office in any other capacity other than the appellate work you did before you were elected?
Not to my recollection, no.
Because we're in an open session and based on some of the guidance from the court, I'm going to ask you questions. Well, let me back up. How many prosecutors are in your office right now?
Well, that are with our courts that are actively engaged in our court system is 30. And then we have screening prosecutors as well. And that would be another 7 or 8.
Okay, so I'm going to try to.
I should stop because I also, my executive team, they don't have courts. So there's another 5 of them as well.
Okay, so let me ask a better question. How many prosecutors in your office represent the state in felony matters?
Well, all of them that I just described.
30?
I mean, even the screeners. Yes, the screeners, my executive team, they are assigned to special cases. Usually my executive team, for example, aggravated murder cases, some homicide cases. So they also are prosecuting and represent the state in trials.
Can you explain what you mean by the executive team?
The executive team would include, obviously myself, I have 2 chief deputies, 1 chief deputy, another chief deputy's general counsel, and then I have a division chief over major crimes and a division chief over general crimes.
So is it fair to say that there are at least 24 prosecutors in your office who have substantial experience prosecuting serious offenses?
24. I don't know that I'd go as far as 24.
Okay.
Certainly all my SVU attorneys have that experience. Most of my violent felony attorneys have that experience too, but not all.
Okay. And do you know how many attorneys in your office have actually participated in homicide litigation?
I don't know the exact number, but I would say maybe 15.
Okay.
But I guess I should clarify, not all of them have the experience in aggravated murder cases. And that's why we specially assign those attorneys.
Understood. And how many do you believe have experience in aggravated homicide cases?
Probably 7 or 8.
And are all 7 or 8 assigned to this case?
No.
Are the 5 other than you who are assigned to this case experienced in aggravated felony cases?
4, well, I'd either 3 or 4.
Of the 5?
Yeah.
Okay. All right, now I'm going to ask you some questions about a specific member of your office. And because the court may or may not ultimately order that attorney's identity remain sealed, you know what I mean by the word sealed, right?
Yes.
I'm going to refer to that person as Prosecutor A. Okay, you all right with that?
Sure.
Okay. So how long have you known Prosecutor A?
About 3 years.
In your work as appellate counsel for the state, did you have any contact with Prosecutor A?
I may have. I don't recall. We generally send something out when we get an appeal, we generally send the AG's office, we send something out to the prosecutor, ask them to fill out anything that we should know. More often than not, they never send us anything. And because it's an appeal, I mean, we're bound by the record. So there's not usually an occasion, but sometimes there is. But I couldn't say for sure that I've never talked. I certainly don't remember ever talking to him, though I could have.
Okay, is Prosecutor A member of your executive team?
Yes,
And did you select Prosecutor A to be a member of your executive team?
yes,
And that was at the beginning of your
yes,
tenure as the Utah County Attorney?
yes,
All right. And so you've had close working contact with Prosecutor A, who's a member of your executive team for the past 3 years.
yes,
And that, unless you're out of the office traveling or on vacation, that's basically every work day of the month, correct?
yes.
All right. And have you met members of Prosecutor A's family? Ever? Let's just start with ever.
What's that?
Ever. Have you ever met members of Prosecutor A's family?
I have met his wife.
Okay.
I don't know if I've met his kids.
What does this have to do with
I
anything?
may have in passing, but I don't really. If I did, it was like at a function, they say, "This is my family," and introduce me, but I don't remember.
Have you socialized with Prosecutor A and his wife?
I think we went out to dinner once after a conference in St. George with some other prosecutors and their wives.
Okay. Have you ever been to Prosecutor A's home?
No.
Has Prosecutor A ever been to your home?
No.
You engage in recreational activities in any way with Prosecutor A?
No.
Whatever you do, running, pickleball?
No. I need to do more running, but unfortunately I don't.
All right, understood. Okay, now, Prosecutor A has an adult child
Oh God, here we go.
who was at the September 10th rally at Utah Valley University, correct?
That is what I mean, I don't have personal knowledge of that other than what they have told me. So like, I never saw that adult child, but I'm assuming, yes, that's true.
Okay, but on September 10th, 2025, at the moment that Mr. Kirk was shot and ultimately died from that shooting at Utah Valley University, you were in Davis County, right?
Yes, I indicated in the motion that it was Ogden, but it was actually Layton. So it was Layton.
Layton.
Yes.
Okay.
And I think that's Davis County.
All right. That's what I thought. And Prosecutor A was with you?
Yes.
Okay. And isn't it true that while you and Prosecutor A were in Davis County, you learned from Prosecutor A that one of his adult children was at the rally and was texting him about their experience?
Yes. I mean, we had just broken for lunch and he showed me the text, Charlie Kirk got shot.
And that was a text that he showed you was from one of his children, right?
Yes.
And you knew at the time that it was a text from one of his children, right?
Yes.
What did he say to you? So I'm talking about Prosecutor A.
He said, look at my daughter, look at what my child just showed me.
Daughter.
And that's about it. And then he said, I should be getting down to UVU.
Okay. And then he left.
Yes.
And he, as far as you understand, he drove down to UVU.
Well, he drove towards UVU. Yeah. He drove in the area.
Okay.
Ultimately, I met him and then we drove together to UVU.
Okay. So you, according to the pleading that you authored the pleading that was filed.
Yes, I did.
Okay. So that, for the court's benefit, that's the state's opposition to the motion to disqualify. You
Yes.
authored that, correct?
Yes.
All right. And in it, you said that 10 to 15 minutes after Prosecutor A left the event that you were at in Davis County, you left.
Yes.
Did you also head in the direction of UVU?
Yes.
Okay. And then you and Prosecutor A met up somewhere.
Yes.
And then traveled to UVU together in your vehicle or in Prosecutor A's? I guess there's a third alternative, which is you met somebody else and traveled with
No, I don't remember whose vehicle it was.
All right, did you talk to Prosecutor A?
It was my vehicle, I'm pretty sure.
Okay.
So,
And was that just about logistical convenience, like let's just go in one car, or was there
Yeah.
some specific reason?
yes, no, that was no other reason.
Okay. And on your way to that, what I'll call the meeting point,
Uh-huh.
did you have any conversations by telephone with Prosecutor A?
Well, yeah, because we needed to meet. He left. I thought I would get some lunch first before I went to the command post. I got about halfway through that and said my mind was not on it. I needed to go to there. And so then we called. I believe I called him or he called. I'm not sure who called who, but then we met. We hadn't arranged that when he left.
Understood. But did he convey to you any more information about his child's experience in those conversations?
No,
Okay. And did you inquire, like, how's your kid or anything like that?
I did not.
Okay. And so you met up and then you went to the command post, which was established near the university, correct?
It was at the university.
Okay. Was it inside one of the buildings?
What's that?
It was inside one of the academic buildings.
Yes.
And did you see Prosecutor A's child there when you were there?
No.
Were you introduced to that person?
No.
Okay. Did you have any conversations with Prosecutor A about whether they should stick around and wait?
No.
Did you?
My understanding my understanding was that everybody had left. We were told that most of the students had left. They had not, or attendees. So.
Okay. So as far as you know, Prosecutor A's adult child had left the university before you.
As far as I know, my understanding was that, most of the students had fled. At first they went into buildings or whatever, and then they made their way out.
Yeah, we should start.
You are
letting go.
aware, I'm sorry, that's not a question. Give me a second, Your Honor, if you will. Okay, so did you spend time with Prosecutor A at the command post on September 10th at UVU?
Yes, we were going different places, but there would be times that we would meet up. But off and on is all I can say.
Okay. And did there come a time, either on the 10th or shortly thereafter, where he provided you with some information about how his adult child was doing, having been at the
I don't remember him ever saying anything about that. And I never asked. I probably should have. But I don't remember any conversation regarding his child.
Was there anybody else at the rally who you are friends with, or is a relative of yours, or a close coworker that you're aware of?
I know that there were some people in my LDS ward whose children were there.
Okay. And when you say some
everybody
people,
was
could you
fucking
be a
there,
little more
probably.
specific? Like how many
Just
different families?
members of the ward.
Sure, but do you know how many different families that would be?
I think I was told about 2.
Okay. And who told you that?
One of the families.
Okay, so one of the families in your ward informed you that one of their own children had been there, and then another one had been there?
And then somebody else from the ward had been there.
I see. And do you know who those people are by name? I'm not asking you their names. I just want to know if you came to learn who they are.
Yeah, I came to learn who they are. Yeah.
Okay. And are you close with those people?
We're casual friends with one of them. But I don't think I learned that until well after we'd filed the information.
Understood. When did you learn that?
Sometime after. I don't know.
So the information was filed obviously in mid-September.
Yeah, just in 6 days. So.
Right. Okay. And do you know, like, if you saw the children of the families in your ward who you understood were there, if you saw them on the street, would you recognize them?
I would recognize at least one of them.
Did you ever have any conversations with them or their parents about their experience?
I tried to stay away from that, other than they told me that the one was doing just fine and the other one was shook up.
Okay. And the other one was shook up. I mean, is that the term used, or is that just your way to summarize?
That's my way of summarizing it.
What did they tell you?
Having a hard time with it or something of that nature.
I'm sorry I interrupted you. So somebody told you, somebody who you know from your ward,
Yeah.
told you that their child is their child a student at UVU?
Probably. I mean, they're young adults, so I'm assuming that. I really don't know for sure.
How about say,
Yeah.
I
think what you
don't
said
know.
is that they told you that their child was having a hard time with it.
What, that, not their child, but the other family's
Other
child.
family's child.
Yeah.
Okay, so it was like a secondhand thing.
Yeah.
Okay. And do you know if
Is that
either of
hearsay?
those young people who were at the rally, well, I'll put it this way, do you know where
You're
they
supposed to be an
were
attorney, right?
in terms of in what I'm going to refer to as the amphitheater
I
area?
have no clue.
The one who was having a hard time with it,
Mhm.
did you share that information with the prosecution team?
Isn't this again hearsay?
I may have. I
may have.
don't remember. I may have in passing.
Did you ever suggest to any of the law enforcement officers that that person be interviewed because they were impacted by what they experienced?
No. We don't interfere with the investigation. We try to assist. But law enforcement, they identify who they want to locate and who they need to interview, and I leave that to them.
Did the person giving you this information, so this is another adult in your ward, tell you more specifically about what their child and the other child actually saw and experienced?
No.
Okay, so you don't really know much more about where they were, what they saw. All you really know is one of them was having a hard time
Yeah.
with the experience that they had.
Yeah.
Okay. I understand you said that you don't interfere with law enforcement, but if you learn, even if it's somebody you know through your community, that somebody has suffered some emotional harm as a result of a criminal act that you are responsible for prosecuting, that's not information you would give to an investigator so that they could determine whether or not, so that they could go interview that person.
I didn't consider that as really relevant to the investigation, so no.
The fact that this young person was having a tough time with what they experienced is what you're saying isn't relevant. When lawyers use the word relevant, we got to.
Well, it's relevant to them. As far relevant as to our case, I don't believe so, no.
Okay, understood. Now, there was a point in time in October, I think it was October 20th, where Prosecutor A sent Mr. Robinson's counsel an email disclosing that his adult child had been at the rally, providing us with some information.
Yes.
And so my first question is, were you part of a decision to disclose that information?
Yes.
Okay. And were you part of a decision as to how that information would be disclosed or how much information would be disclosed? Like what led to that email?
Well, there was no decision needed as to how much. The decision was to provide the information that we ultimately provided you. And that is not because we believed that there was a conflict of interest, but that was out of an abundance of caution.
I understand it's your position that you don't think that there's a conflict of interest. But I think that's clear. All right. Did the entire prosecution team, as it was constituted on October 20th, discuss this bundle of information that was being disclosed, or was it just you and Prosecutor A?
I know that me and Prosecutor A discussed it, and he may have discussed it with others. I don't believe anybody else was there.
When you discussed it?
When we discussed it, one of them may have been, or two, I don't know.
But the information that you obtained sort of if I may, in the heat of the moment back on September 10th in Davis County, that Prosecutor A's child had this experience. And the text messages that went back and forth in the family, that information was shared with the prosecution team, correct? Everybody knew eventually.
Eventually.
Sure.
I mean, yeah, eventually.
Okay. So,
I mean, I only knew the fact that she was there at the time. I only knew that she was there and that she left. That's all I knew.
Okay. But is it fair to say that you didn't set up any, but I'm going to use a term like firewall, to keep the rest of the prosecution team isolated from this information that one of their colleagues' children had this experience at UVU on September 10th?
No.
Is there a written policy in your office, either that existed when you arrived or that you've prepared since then, for how to evaluate whether one of your prosecutors needs to be screened off from a case?
You know, I'm not sure. I mean, we have those conflicts that come. I mean, the biggest thing on screening for us is if there's a potential conflict where information that the defendant has, one of our prosecutors has, because that's why you screen cases, is to make sure that shared confidences aren't also disclosed to, shared confidences with the defendant aren't shared with the prosecutor.
But you could agree with me that there are other types of conflicts that can arise other than what we might call the, privileged communication.
There may be. I mean, I think there can be. I can't think of any right now, but I think the rules are pretty clear with respect to shared confidences. You can't, screening isn't the end all of of how you treat conflicts. I mean, generally speaking, we will just conflict out to another office if we feel like we need to. One example, well, I won't go into that, but I mean, we've been threatened before and there was an investigation. And of course, we conflicted it to a different prosecutor's office because in that case, we were potential targets of this.
They were mean and scary to us, so we told the other people, yeah.
Okay, so you're not sure if there's a written screening protocol, but what you're saying is when we know when we see it.
Well,
sort of what I'm hearing you say.
Oh my God. Yeah.
Sometimes we do. Sometimes I've had attorneys that felt like they couldn't talk after they've been conflicted.
This is literally all still talking about the fucking kid.
But notify the victim that there was we were going to switch the prosecution. But There may be, I just honestly don't know.
This entire
We keep
fucking 4
an
hours
eye
has
on
been
those
talking about
things
this
and
damn
rely on our
kid.
attorneys to notify us when there is a conflict.
But you knew as of September 10th that
It's okay,
Prosecutor Hayes'
Sophia.
daughter
This has been a very boring live.
attended the rally,
If
correct?
this is not done by
Was in the crowd.
5:30, I'm kicking everyone out and taking
Yes.
over.
Heard a shot fired, correct?
That, at that moment, I don't know that I knew that.
Yeah, but you know it as of today.
Sure, I
because
know
you
it
read
now.
their affidavit,
Sure.
which says that.
Well, I knew it. I knew it once all of that information was disclosed to me.
Okay. And that they had to, with many, many, many hundreds of other people, run for cover and get out of the open space where they were, correct?
Yeah, I don't know that they had to, but that's what they did.
Well, you've seen the video of, I mean, you've probably seen many videos of that day, right?
Yes.
And weren't there law enforcement officers basically directing everybody to leave the open space so that they could?
I don't know that I remember seeing it, those videos of the students or attendees leaving. I mean, I know that they left. I know that they ran away.
I guess it would be
I'm just,
5:30. So
what we learned later is that the
so
shooter left
7:40
immediately after the
guess.
shot.
or
But
7:30.
at the time of a shooting, you don't know
Sure.
how many shooters there are,
Absolutely.
if there's going to be
Absolutely.
follow-up,
Right.
if there are explosive devices, like all those things, right?
Sure.
Okay, so let me ask you these questions about, well, instead of giving you a headline, I'll just ask the question. Once you had all of the information about Prosecutor A's
This is going to
child's
be a horrible
experience,
fucking trial.
okay?
Mhm.
What they saw,
I don't even
what
know
they
what
heard,
this
what
whole
happened to
meeting
them,
is.
the fact
Something
that they were
about
separated from their
evidentiary.
personal
I don't
property,
know what that means.
all those things, okay? What I'm hearing you say
The
is you
fact
never
that
really
we're
discussed that
literally
with
going on
Prosecutor
for
A and stuff.
3 hours now about
No.
some
I
fucking
mean, I did
prosecutor's
discuss-
child who was at the Charlie
I don't
Kirk
know if it
event
was
is
day 2 or day
ridic-
3.
ridiculously retarded.
Law enforcement was there
Hopefully it
on
gets
the
better.
day of the shooting,
Ugh.
the next day, and I think into
So
Thursday or
Sophia, they
Friday, I
tried
don't remember
like
exactly
they
what
tried
day.
3 times to get the
At some
cameras out of the
point,
courtroom
I
today.
was told that Prosecutor A's child left the bag there.
This is dog shit.
Okay. So if you never really talked about it with Prosecutor A, about the impact on
Yeah, we're falling asleep here.
this
At least I
child
am.
and the family.
I didn't say that. Not on the day of, or, I mean, in the intervening time, he reported a couple of times that he talked to his child and said that she was doing fine. She reported to him that she was not having any issues.
So yeah, Sophia, it didn't work, but we can no longer look at Tyler Robinson. He can no longer be on camera. They got mad.
Did you ever ask
Very
him,
sad,
well, what
sad.
about you? I mean, your kid was
They
at this-
cry. And
I
Jen said,
didn't.
too bad.
Not that I recall.
Did you ever consult with anybody in the Attorney General's office concerning whether Prosecutors A's child's experience raised a potential conflict of interest for your office?
No, that's what I did for 23 years with prosecutors, is consult on that. And so I didn't feel a need to go to those folks. I mean, I know how to try to figure that out.
So when one of your responsibilities in the Attorney General's office was to consult about ethical issues?
Different matters.
Different
I mean, it could be a variety of things.
Okay.
And I mean, if you're talking about ethical issues in particular, I don't know that the Criminal Appeals Division was the right folks to consult, but I'm not even sure of who from the Attorney General's office would. So.
Okay, but you worked in the Attorney General's office for a couple decades, right?
Yeah.
And what you're saying is that in your role as an appellate lawyer for the state, you would talk to prosecutors
Oh,
guess
yeah.
somewhat more informally.
Correct.
about ethics.
Princess Sophia, this
Yeah,
guy,
every
this
once in a while, yeah.
defense attorney is
And
the biggest snooze fest ever.
Oh my God. Yeah. Thank God you weren't
so my
here for the
question is
earlier
whether
part.
you reached out to anybody in the attorney
We
general's
survived
office
it for you.
about this
Okay.
particular
Yeah.
It was
issue.
To bring
fucking
you an
horrible.
updated of nothing.
Did you, and when I say you, I really mean you or anybody in your office on your behalf.
Okay.
Okay? Because you're the chief prosecutor, right?
Yeah.
So when I say you, I
Yes.
mean you and
Okay,
people who work for you. What about the Utah State Bar?
no,
I mean, they give the ethics guidance to attorneys on
Private
all kinds
chat.
of issues, right?
yes.
But no
No.
reach out. Other county
Working on it.
attorneys in
Stop
Utah,
interrupting me,
in other words,
fucker.
your colleagues who are elected
Did you just swear at me?
Yeah.
chief prosecutors in their counties. Did you discuss this with any of
Rude.
them?
No,
Are you a member of organizations of what I'll call chief prosecutors?
Oh my
I'm a member
God.
of the Utah County and District Attorneys Association,
Okay.
UCDAA. I'm actually the president
Oh
of
God.
that organization.
Of course you
I'm a
are.
Who
member of SWAT,
cares?
which is the statewide
Who
association of public attorneys
Dude,
and
day one
prosecutors.
is dog
I'm
shit.
I'm actually the president-elect of that organization.
Ugh.
That's a lobbying organization.
Oh my God,
Okay.
he's a
And
lobbyer.
do,
Oh my
Fucking
God.
lobbyist.
associations have any
You have
mechanism
a
for
super PAC
providing
now?
ethical guidance to
Lord.
their members?
No, I mean, when we have questions, we may shoot out an email and
Right,
ask about
Giggles?
things.
Did you do that in this
No.
situation?
Well, Giggles,
I
it might get
consulted
interesting next
no
week
one
as we
other than
as they
my
like,
Yeah.
present
Okay.
evidence and
I'm
shit.
going to ask you 3 more categories.
Even though this is the
Okay.
evidentiary
Reach
here,
out to
so
any law
we'll
professors
see what
who
happens.
No,
report to be ethics experts?
no,
Did you speak with any judicial officers
No.
about it? Court reporter, get the question and the answer. Oh, there you are.
well, I just said that.
Sorry.
Did you ever discuss with prosecutor A whether his child should or should not be interviewed by law enforcement?
No,
Did- Are you- are any-
maybe, I don't remember. I'm,
Okay, so that may be important. You want to take a minute to think about that?
what's that?
That
Jesus.
may be important. Would you like to take a moment to think about it?
I don't remember. I don't think so, but I do not remember.
He might have had just a little bit of sass there for a minute.
Yeah. Little
Keep
bit.
up with it. Keep it. Keep going with that sass. Because, bro,
he's
you're
a sassy
boring
boy.
AF.
He's a sassy boy.
Boring AF.
The brief that you filed on behalf of the state, I'm sorry, the opposition to the motion has a couple affidavits attached to it, right?
Yes,
Okay. And one of those is the affidavit of Cole Christensen.
yes,
And the court's benefit in the record is addendum C to the opposition. Special Agent Christensen writes in his affidavit that you and he in mid-December, so that's after the motion to disqualify was filed,
yes,
went to UVU and basically conducted some observations and measurements, right?
yeah. He was investigating that part. I did go with him because it involved it doesn't involve trial. It's never going to come out in trial. So I did go there and assisted him. But he also had another officer there so that anything that I did could be corroborated by that officer.
Okay, but isn't it fair to say that basically what happened there is you said generally, Mr. Robinson's defense counsel have filed this motion to disqualify. I want to have some measurements done because I want to figure out what risks there were to Prosecutor A's child based on where they were and where you believe the shooter was, right?
Yeah, we have very good evidence of where the shooter was.
Okay, so I want to,
and it was based on Prosecutor A's child indicated where the location that they were, I'll use they, and based on the evidence of where the shooter was. So we wanted to confirm that. Now they didn't know where, obviously where the shooter was, but we wanted to confirm based on, we knew where the shooter was. And so we wanted to confirm that, that they weren't in the line of fire. And that was important because that's critical to the state's case, is whether or not someone's in the line of fire.
okay, so there's a few things there I want to try to make sure I cover. And if Your Honor, if there's any point in time where the court or its staff need a break, just tell me, because I can break whenever the court needs it.
We'll be taking a break shortly, but I appreciate that. And if any of the parties do need a break, please indicate it as well. I want to be respectful to all parties.
Thank you. So the first thing I want to address, Mr. Gray, is that you knew that the defense had filed this motion to disqualify based on the relationship between Prosecutor A and somebody who was at the rally.
Yes.
And had the experiences that the court has already heard about. And so you basically went out with a law enforcement officer and you did an investigation and took a number of measurements.
He did, yes.
Okay, but at your direction, right? Because you're the one.
I asked him to do that, yes.
Okay. You say in connection with that there are some uncontested issues in this case.
Yes.
That's a term you used in your brief, right?
I'm sure that you will tell me where they're not contested, but.
Well, every issue is contested, right? I mean,
So is it, okay, go ahead.
I'm not trying to have a argument because the court reporter doesn't.
I
to speak
stopped,
over each
so
other.
I'm not.
And I'm bad at that too. And I have been for a very long time. But your measurements as documented in Mr. Christensen's affidavit, Special Agent Christensen's affidavit, are of things that you say are uncontested. But I just want to make sure.
So can I clarify that? I never said that the measurements were not contested. I said what was not contested is the fact of the things that Child A could testify to. That's what I was referring to is what's not contested. Child A, as demonstrated in the affidavit, can testify that Child A was there, that her Child A's location, and what the crowd did, what she did, and then what she ran in. That's what's uncontested.
But aren't these also uncontested things which you contested issues which you seem to suggest to the court are uncontested? And that is that the shooter was on the roof.
No, I didn't say that was uncontested. I said what she could testify to is uncontested. And if there was something different than that, that's certainly what I meant. I understand that all those other things could be contested.
Okay. You've made yourself a witness to evidence that you've used to try to advocate to the court that there's no conflict of interest, right? I mean, you basically, even though you're representing the state, you went out and you participated in a what you hope is a systematic way to measure whether Prosecutor A's daughter was in a line of sight from the place where the state alleges the shooter was, right?
Sure.
Okay.
But as far as making myself a witness, I was careful to make sure that there was Cole Christensen and then an officer from UVU. If you look at the case law says that prosecutors can participate in these interviews and so forth. What we do is make sure that someone else is there so that we don't have to testify. And the defense can't force the prosecutor to testify under those circumstances. That's the case law.
It won't surprise you that competent defense counsel have the same practice. We don't interview witnesses without investigators present.
Right. And this was no different than that.
Understood. Okay, I do want to address another aspect of this line of fire situation. Okay, so it's the state's theory of the case, if I may, that the shooter was on a rooftop, correct?
Yes.
Okay. And what's the name of the building that the state believes the shooter was on?
I don't recall.
Okay. And so these measurements that are in Special Agent Christensen's declaration, you're saying were designed to basically, if I may, I'm not trying to put words in your mouth, rule out whether the child of Prosecutor A is in some ways a victim of this incident.
Not as far as a victim. We already understood that based on where the buildings were, that the child was not in that line of fire, but we wanted to provide the measurements for this motion.
So what is the significance of the measurement? What is the significance of whether the child of Prosecutor A was or was not in a physical position where they could have been shot? What is the significance?
The aggravator, as you know, is that we're alleging that when the shooter killed Charlie Kirk, that he placed others in grave risk of death.
And you've
so
now,
anybody within that zone, if you will, was placed in grave risk of death.
okay, and so you've now gone out and you've done these measurements from the place where you believe the shooter was. And anybody who's positioning at the rally, there's no line of sight. You're basically excluding all of those people from being among those.
Oh my God. Well, guys, what do you think? That's absolutely brutal. We can't hear secrets, so everyone let her know that she's quiet.
Oops. I was just saying, like, yeah, it's all about that attorney's kid. Yeah. This is just dumb and boring, and I'm falling asleep, and I'm annoyed, and like, I hope it gets better than this, because if we're gonna cover this, this is just bad.
It probably won't.
Oh, I hope so. because this attorney is at least a different attorney. Like this guy is just terrible. He's a snooze fest. So we're gonna cut it off here, but I am going to lock Rabbit up, and I'm taking over. I'm taking over the stream. Where's that picture?
Yeah, that's what it seems like, Giggles. That's why they're trying very, very, very hard to keep her identity secret.
Mm-hmm.
Very
we already
hard.
know it's a daughter of somebody named, or like a friend of Mr. Gray. Like, I would think it's like hearsay. I'm not sure. Like, it's just dumb. Throwing the rabbit out, suit and all, suit and tie, with his glasses and everything. She may know Tyler a little too well and not sexually. I don't know. But it is rather annoying. I'm bored. So we shall all see you back here in 15 minutes because I have to go and run upstairs and kick this boy out. Kick this rabbit bunny boy out of here. Do you have anything to say, bunny boy?
Nope. Goodbye.
Bouge, 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 bouge. Enfin, bouge. Faut mettre la basse à l'aise. Come here.